May I have my lord's kind leave to mention one order particular matter?
I'm not mentioning legal. Your lordship kindly take notice of that AC, my lord. Your lordship direct inform the. Let it be check up once. এইটাতে হচ্ছে স্মোকটা বেরোচ্ছে না we do not know whether it is smoke or what. Aircraft, we get those kind of the cold.
Yes. There has been no heated arguments yesterday or today. There is nothing.
But I do not know. But
who knows? Maybe it started day before yesterday.
yes.
May I have my lord's kind leave, my lord, to mention, my lord, I was seeking for my lord's leave, my lord, to prefer the appeal without the certified copy of the order, my lord. Order was passed on 6th, my lord. It was uploaded on the server on 7th, my lord. Commercial division, my lord, at Rajarhat. Commercial court at Rajarhat, my lord.
6 what?
6th of June, my lord.
Like for certificate copy.
Yes, my lord.
Hello, may I permit to mention, my lord, the matter of
Grateful.
petition was disposed of by your lordship on 12th of May. Order was not uploaded, but surprisingly, order has been rectified by subsequent order of 7th June 2022. In order is not been uploaded. For this surprising mind, how it can be again? Can be. If there is a wrong order, it can. Lawyers who are appearing for the petitioner, they are not me or my junior. No. Let us see. A file to bar kore. It should be uploaded. Next.
My lord, may I be permitted to mention, my lord, or item number 197 of today's list, my lord. This is assigned matter, my lord, habeas
We are
corpus.
hearing at the assigned matter, sir.
Yes, my lord, kindly.
Oh, sorry. We are hearing already one matter. Let us see. It was supposed to be completed today. Yes.
My lord, should I mention, my lord, a few days after?
That is. Yes. Next.
My lord, as to contempt petition, my lord,
Sorry, contempt. Let us see. We are in the midst of a main matter. Let us finish first this matter.
Lordship may permitted to mention. Lordship, the name of petitioner is wrong in order sheet. Lordship, petitioner press for
Give
correct the
correction.
name of.
Yes. Yes.
May it please your lordship. My lord, as my lord submitted yesterday.
Oh,
my lord,
plus, sorry, show us that particular correct section 10C.
I have also checked. My copy was right. The compilation copy, which was given to your lordship, that was not right.
That's
But
my lord, I'm handing.
I was feeling, fortunately, I did not take any of the points basing on any of the words in that incorrect. Yeah.
My lord, the correct provision should be before.
Yeah,
your
that's
lordship.
true.
but where is Mr. Sanyal and where is his junior? This is not expected that a incorrect section that would be.
I remember lordship was asking me to follow the compilation, but since I have already marked my copy, I was following mine, which was the right one, fortunately.
But I'm handing up, my lord. I'm just giving a.
No, I just wanted to know the difference.
But the material purpose, possibly there will be no difference.
I just wanted to know the
Yes,
difference.
correct. So there is a full edge. As amended. My lord, I have given, my lord, the amending act, my lord, which is at page.
No, I just wanted to look at the section. Where is a 2097? This is a bill. This is the Act 87.
My lord, all that I'm pointing out is, my lord, your lordships will find it at two places. My lord, in the compilation I've given. My lord, the earlier page, my lord, is 104, which is, my lord, the Amendment Act of 2017. My lord,
Oh,
bottom,
this
my
is
lord,
where
your-
is the amendment of 2017 bill, and the Act is 104.
And my lord, section 4 of the amending act gives 10C. This is the full provision. What has been given.
What is the difference? Ninety-one to the.
That for 1 minute, my lord, your lordship will find, my lord, 10C, my lord, in interest of education or in the interest of.
The word
public
and,
service.
the word and or both have been introduced.
And in the interest of public service for administrative reasons. Not interest of public, for administrative
Yes,
reasons.
yes, public
service.
service.
He was following ChatGPT for the legal purpose.
Oh, they have, yes, public service for administrative reasons.
But, it's not, my lord, interest of public, it's public
No,
service.
it's a public service for administrative purpose.
I don't know how it was done.
May, but not just that, my lord, may,
And or হবে na, or হবে and what the bhool.
my lord, something more, may direct the commission through guidelines or general instructions.
Correct. Through guidelines or general instruction is correct. It is
Not
also,
there.
oh, acha, sorry, I was looking at,
It is not there.
oh,
This is
is not expected.
no, this is the real hangover syndrome.
Anyhow, the book, I do not know which book.
But I have given your lordships, my lord, oh, what has, it's been copied from, my lord,
It's
headmaster.
a headmaster's manual. That's why, who has?
But, there is, my lord, an education manual, my lord, which has, my lord, the correct, my lord. And I have, my lord, extracted that, the entire act after amendments. Your lordship will find, my lord, in this compilation itself. My lord, starting at, my lord, page 124.
Which one?
Lord, this very compilation with all the amendments, my lord, page 124.
120?
4.
Just 1 minute.
Act of stated lawyer.
Now, compilation
124.
like the written also.
That's the Service Commission Act. Yes,
Spare copy only. Yeah,
Yeah.
yes,
Chamber junior court chief is not employed by the state.
yes.
My lord, I kindly note also one thing. My lord, on a lighter vein. My lord, there is no one else from the state.
That's true. That is what we notice. Sometimes only for the purpose of,
My lord, it happened, my lord, in the
again on
DNS
a
allowance
lighter
matter,
side, may I use the word, only for the purpose of parking
Yes, ma'am. my lord, your lordship recalls, my lord, DNS allowance matter, same thing. That is, my lord, what makes it more difficult, my lord. That is what makes it more difficult.
True.
I think, my lord, I don't mind working, my lord. I still have, my lord.
No, that's
the
true.
ins-
That's true.
my
We have
lord, the-
noticed. Yes.
Now, my lord, may I, my lord, just, my lord, with, my lord, 5, my lord, prefatory words, my lord, or sentences, my lord, indicate, my lord, what, my lord, we also have to keep in mind, my lord, when deciding, my lord, the issue, my lord, which your lordship is, my lord, lordships are deciding. That's, my lord, the validity of section 10C, my lord, of the Act. Now, my lord, the first thing, my lord, since the attack, my lord, before your lordships, is, my lord, by, my lord, teachers. So, my lord, the first question, my lord, which has to be, or the first issue which really needs to be looked at is, my lord, the nature of employment, my lord, of, my lord, the teachers. My lord, in aided institutions.
Yes.
Second, my lord, what is the nature of service, my lord, of, my lord, these, my lord, teachers.
Yes.
My lord, third, my lord, the role of the government, my lord, in education.
Yes.
Fourth, my lord, is a subset of the third,
Yes.
is a subset, my lord, of the third, the fourth. My lord, in school education, my lord, what are, my lord, the obligations, my lord, of the government? And what are, my lord, the duties, my lord, of the government?
Yes.
And lastly, but not the least, my lord, the, my lord, historical backdrop to not only the legislation, but, my lord, the, my lord, role of government, my lord, in school education.
Historical backdrop of the legislation
Legislation and, my lord, role of government,
vis-a-vis the role of government.
no, and role of government in, my lord, school education. My lord, how it's evolved. My lord, I just,
Yes.
my lord, I have, my lord, been lucky, my lord, to see it, my lord, at a fairly personal level because of, my lord, the Umadas Memorial School, my lord, being right across the lake, my lord, in our village.
Now,
In our village, my lord.
Acha, in a village.
My lord, I have seen, my lord, how it's grown. My lord, Mr. Shankardas Banerjee's, in his father's memory, my lord, that school, my lord, was set up. It was, my lord, for, my lord, the local populace. My lord, everything was sponsored by that family. Everything. Then we had independence. My lord, we had, my lord, an Education Act of 1950. I've given all that, my lord, compilation there. The, my lord, policy which was followed, my lord, was of a deficit grant. School collects whatever it can from people who come for education there, from parents, from donations. And, my lord, in the event of there being a deficit, the government steps in. To, my lord, where it stands today. Because all these, my lord, make a difference. My lord, in, my lord, the role of the government. So, my lord, these are, my lord, matters, my lord, your lordships kindly bear in from time to time, my lord, I will, my lord, go through this. Second, my lord, aspect where I need to, my lord, because a lot of cases, my lord, have been cited. My lord, I was going through them. And, my lord, some I had gone through earlier also. My lord, is, my lord, when we are really concerned with, my lord, legislation, my lord, by, my lord, the Legislative Assembly, and there is a challenge to it, my lord, the challenge really has to fall, my lord, the grounds of challenge, whether it's parliamentary or state legislature, my lord, into 4 grounds. Your lordships had indicated it, but I'm giving that case and just citing one paragraph, my lord, for, my lord, being, my lord, clear in this, because I think with the greatest of respect to my learned friends, my lord, some of them, my lord, have, my lord, I don't wish to take names, my lord, really, my lord, gone beyond that, my lord, in making arguments. So, my lord, my lord, just, and your lordships are aware of it, so I'm not going to go into it at length. I'm just giving it, my lord, straight, my lord, upfront, my lord. That is, my lord, the decision, my lord, reported in 2016, 6 Supreme Court cases, page 1. 2016. (2016) 5 SCC, my lord.
Not 6.
Not 6, my lord. 2016 5 SCC, page 1. My lord, kindly just take para 857.
Such a longest judgment.
My lord, this was, my lord, it has now become the lead case.
Page type of-
My lord, para 857 at page 643. Supreme Court advocates on it.
Para 80,
That's the
para
My lord, para 857 at page 643. My lord, after analyzing all the cases, that's why I've given this, my lord.
NJC. All the 5 judges have.
Now, my lord, kindly have a look at, my lord, para 857 bottom of page 643.
Yes.
Now, my lord, kindly see, strictly speaking, therefore, an amendment to the constitution can be challenged only if it alters the basic structure of the constitution. And my lord, now this is the second part. And a law can be challenged if it is beyond the competence of the legislature, it violates Article 13 of the Constitution, it is enacted contrary to a prohibition in the Constitution, and it is enacted without following the procedure laid down in the Constitution. Like, my lord, 304, my lord, presidential, my lord, approval before, my lord, moving it. That's a procedure prescribed. If that has not happened, it will go. Then, my lord, there's a prohibition in the Constitution. My lord, an example, my lord, interstate river, my lord, issues, my lord, there, my lord, there's a prohibition. It can't be looked into. And beyond competence, that's, my lord, Schedule 7, the various lists, my lord, if, my lord, competency is not there. And, my lord, violates Article 13. That, my lord, is 13(2), my lord, which is, my lord, in our case, my lord, that is, my lord, the fundamental rights, part 3, my lord, of the Constitution. Now, my lord, 1, 3, and 4 are not an issue here at all. Not an issue here at all. Arguments have been made, my lord, that it's in violation of Article 13. Now, my lord, why violation? My lord, what has been argued is, my lord, Article 14 and, my lord, Article 21. These are the two. My lord, 19, my lord, may have been, my lord, taken in, my lord, some pleadings, but has not been argued at all. Now, my lord, I kindly take 858. That same. I'm only emphasizing this because several of the arguments are on possibility of abuse. Kindly see. At the same time, it has been emphasized by this court that the possibility of abuse of a provision of a statute is not a ground for striking it down. An abuse of power can always be checked through judicial review of the action. So, my lord, kindly, my lord, keep just this in mind, considering, because I intend to try and conclude, my lord, in the first half itself, my lord, on this issue. And if your lordships want, my lord, I can give a detailed note, my lord, on the cases cited by them, my lord, because now, my lord, this is, my lord, what, my lord, the position is. Second, my lord, your lord, and reason, my lord, why I am, my lord, referring to this is, my lord, a lot of cases involving delegated legislation.
Now, one thing, because this judgment, I believe, was delivered by 3 or 4, separately by 3 or 4 judges.
Correct.
On this score, what is the view of the other concurring?
No divergence. No divergence. On this, there is no divergence. In fact,
Because I also read much before
Yes.
at the time.
Yes.
After that, nobody opened it
my
for
lord,
this
no,
purpose.
my lord, no divergence.
On recusal, definitely,
Yes,
sometimes I refer.
yes. Now, my lord, on recusal, in fact, my lord, the lead, my lord, Justice Kehar's judgment, my lord, is, my lord, primarily on recusal, because, my lord, he was also, my lord, slated to become Chief Justice. Now, my lord, and the arguments for recusal worked with, my lord, Justice Dave. He, my lord, recused. But my lord, the same arguments, when the bench were reconstituted, and, my lord, for, my lord, a learned judge who was to become Chief Justice. Justice Dave was, my lord, to be, my lord, there's the senior most, my lord, judge other than the Chief Justice. Now, my lord, this is, my lord, the other, my lord, preparatory, my lord, citation, my lord, I am, my lord, making, my lord, before your lordship. My lord, is, my lord, several cases which your lordships will find, my lord, relate to delegated legislation, which have been cited. Here, my lord, it's not a case of delegated
Definitely.
legislation.
In a delegated legislation, there is another 2 points, whether
Your
it has
Lordship-
exceeds the
No,
judicial.
I know your lordships know it, my lord. I'm just, for the sake of completeness,
Yeah.
my lord, just, my lord, doing my lord. This is, my lord, I am, my lord, citing a much.
Sections. Yes.
Now, my lord, I am, my lord, citing, my lord, this decision, my lord, which is a much older, my lord, decision, 2006, 4 Supreme Court cases, 517 on, my lord, delegated legislation, para 15,
1-5.
1-5, my lord. My lord, 1-5 to, my lord, 1-8. My lord, pages 5 to 8 and 5 to 9. There is a presumption in favor of constitutionality or validity of a subordinate legislation. And the burden is upon him who attacks it to show that it is invalid. It is also well recognized that a subordinate legislation can be challenged under any of the following grounds. My lord, lack of legislative competence to make the subordinate legislation, violation of fundamental rights guaranteed under the Constitution, violation of any provision of the Constitution of India, the failure to conform to the statute under which it is made or exceeding the limits of authority conferred by the enabling act, repugnancy to the laws of the land, that is any enactment, and manifest arbitrariness, unreasonableness to an extent where the court might well say that the legislature never intended to give authority to make such rules. Then, my lord, para 16. The court, considering the validity of a subordinate legislation, will have to consider the nature, object, and scheme of the enabling act, and also the area over which the power has been delegated under the Act, and then decide whether the subordinate legislation conforms to the parent statute. Where a rule is directly inconsistent with the mandatory provision of the statute, then of course the task of the court is simple and easy. But where the contention is that the inconsistency or nonconformity of the rule is not with reference to any specific provision of the Enabling Act, with the object and scheme of the parent act, the court should proceed with caution before declaring invalidity. In Indian Express newspapers versus Union of India, this court referred to several grounds on which a subordinate legislation can be challenged as follows. A piece of, now my lord, this is, my lord, what we, my lord, as lawyers were more familiar with, my lord, when we started out. My lord, a piece of subordinate legislation does not carry the same degree of immunity which is enjoyed by a statute passed by a competent legislature. Subordinate legislation may be questioned on any of the grounds on which plenary legislation is questioned. Now, my lord, exactly what fell from your lordship. As I said, in addition, it may also be questioned on the ground that it does not conform to the statute under which it is made. It may further be questioned on the ground that it is contrary to some other statute. That is because subordinate legislation must yield to plenary legislation. It may also be questioned on the ground that it is unreasonable. Unreasonable not in the sense of not being reasonable, but in the sense that is manifestly arbitrary. In Supreme Court Employees Welfare Association, Union of India, this court held that validity of a subordinate legislation is open to question if it is ultra vires the Constitution or governing act, or repugnant to the general principle of the laws of the land, or is so arbitrary or unreasonable that no fair-minded authority could ever have made it. It was further held that the rules are liable to be declared invalid if they are manifestly unjust or oppressive or outrageous, or directed to be unauthorized and or violative of general principles of law of the land, or so vague that it cannot be predicted with certainty as to what is prohibited, or so unreasonable that they cannot be attributed to the power delegated or otherwise disclosed bad faith. My lord, all these, my lord, are available, my lord, for, my lord, subordinate legislation. My lord, as, my lord, the test, my lord, which is formulated, my lord, has, my lord, again, my lord, the introductory words that, my lord, it doesn't enjoy the same degree of immunity, my lord, which, my lord, the plenary legislation, my lord, enjoys. Because, my lord, several of the arguments, my lord, which were made, my lord, were very apt, my lord, for, my lord, my lord, subordinate legislation. But here, my lord, we are concerned, my lord, with, my lord, 10C. Now, my lord, sorry. 2 or 3 provisions, my lord, of, my lord, the Constitution, my lord, while I address the issue of, my lord, nature of employment, nature of service, and role of government. And, my lord, the constitutional obligation, my lord, of, my lord, government. Constitutional obligations, apropos education, my lord, the government. My lord, first is, my lord, Article 21 of the Constitution. Constitution to the Lordship. Lordships have, my lord, the
Yes, yes.
constitutional copy.
এই একটু উপরে এসে বার করো, কনস্টিটিউশন অফ ইন্ডিয়া বার করো।
My lord, I'll get up.
No, no.
I'm grateful. I'm grateful to my lord. My lord, kindly see, my lord, the marginal note or heading, my lord, of this article. This is in part 3, my lord, one of the fundamental rights.
Protection of life
Life
and personal liberty.
liberty. No person shall be deprived of his life or personal liberty
আমার
except
এখানে আছে
according to
লিখেছি।
procedure. I'm sorry. Except according to procedure established by law. Now, my lord, in my lord, Unni Krishnan's case, my lord,
Very well known.
my lord, the Supreme Court, my lord, held that, my lord, right to education is implicit, my lord, in Article 21. Lord, I'm not troubling your lordships with that case, my lord. Then comes, my lord, Article
21A. Letter introduced.
Yes. Now, my lord, this is introduced by, my lord, the 86th Amendment and was effective from 1st of April 2010.
Right to Free Education Act really originates.
And, my lord, is, my lord, a consequence, my lord, of, my lord, that, which says, my lord, the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. Now, my lord, this is, my lord, a constitutional obligation, my lord, imposed on the state.
Borrowed from part 4 to part 3, letter on.
Grateful. Kindly have a look at Article 45 now. Because when, my lord, Unni Krishnan was decided,
Absolutely.
my lord, there was, my lord, no 21A.
No.
There was 21. My lord, Article 45 was also relied on. But Article 45 is still there.
Yes.
Now, my lord, kindly have a look at, my lord, Article 45.
The directive principles, these are the obligation of the
Correct.
state.
Correct. Now, my lord, kindly see 45.
Yes.
My lord, I don't know if your lordships have the footnote, my lord, in that.
Yes.
That was the old Article 45.
Yes.
Lordships
No,
have-
old Article 45 is not reproduced here.
My lord, may I? My lord, may I just read it out? I'll get a photocopy made.
Yes.
My lord, it says, the state shall endeavor to provide within a period of 10 years from the commencement of this constitution for free and compulsory education for all children until they complete the age of 14 years.
This has been brought down to 6 years.
So, my lord, so now this constitutional, my lord, in, my lord, the directive principles, my lord, partial fulfillment happened in 2010
Correct.
when, my lord, Article 21A, my lord, came in. And, my lord, your lordships notice, my lord, Article 21A, my lord, is, my lord, for, my lord, 6 to 14. So, my lord, 45 gets amended because that becomes, as your lordship says, my lord, in part 3. Now, my lord, kindly see, the state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. So, my lord, what do we have?
It is more expensive. It's more
Correct.
expensive or expanding one because it has a two inbuilt obligations. Not only free education up to the age of 6, but it has a further obligation of a early childhood care.
Correct.
Which may be distinct from an education.
Absolutely, absolutely. Absolutely.
That obligation has not.
My lord, what they do, my lord, is, my lord, old 45 is partially fulfilled. My lord, only education, my lord, 6 to 14. My lord, up to 6, education is not there. But, my lord, we are, my lord, still a welfare state, though, my lord, also proceeding at the same time, my lord, to become, my lord, a rights-based society. Fully rights-based. Not, my lord, some, my lord, welfare measures subject to, my lord, ability of the government to pay, but, my lord, rights-based. Now, my lord, so, my lord, to achieve that, my lord, now comes, my lord, as your lordship rightly pointed out, my lord, a wider, my lord, directive principle engrafted into Article 45. Kindly, my lord, see, the state shall endeavor to provide early childhood care and education. So, my lord, early childhood care, my lord, my lord, the child becomes part of the state family.
Under the sovereign's care, under the sovereign's
Correct.
protection.
Correct.
Because in some of the countries, from my personal experience, what I find is the moment the child is born and is being raised or reared by the parents, there is a dedicated department and an officer of the department on a periodical basis, they visit the house. They look at the child, they interact with the child, even he's a toddler. They interact with the parent and particularly the mother, father also. And then try to find out any problems, any kind of a things which is really happening. Maybe a behavioral pattern of the child, something the child sometimes then requires a lot of care and protections. Maybe medical, maybe that the foods which are being provided may not be so good, or there is something. All these things they take care of. They
And
do
your
not
lordships,
leave
my
like
lord, what, my lord, now, my lord, there is, my lord, these guidelines being framed relating to custody matters. Now, my lord, several of these countries which your lordships have pointed out, my lord, the visitation and, my lord, the manner in which a child is brought up by a parent having custody are all under examination
correct,
and, my lord, greater scrutiny
correct,
by this department, which has
Correct.
specialists.
correct. Correct. But I'm saying this is what is a personal
Yes.
experience I'm saying.
So, my lord, all, my lord, these, my lord, are in place. Now, my lord, these are, my lord, the constitutional provisions other than, my lord, list 3 of schedule 7.
And the first responder are the teachers. If the child goes to the school, because the teacher is interacting with the child, they are the first responder. If they find that there is some changes in the behavior of the child, something is going, they want to just find out. And the moment they notice something, they report that this is what I find a radical changes, or I notice a very, the behavior it has changed. Then these departments, they go and then do it.
And my,
Nowadays in our country, I don't think the teachers
no, my lord, I'll give it
respond to
no,
that
not at all.
extent,
My lord, even teachers,
because they call only the parents. Then
Yes.
what is happening?
Yes. and my lord, not only that, my lord, another thing, my lord, in, my lord, other, my lord, nations, my lord, it happens, my lord, children of tender age, my lord, who are going to school, my lord, they have, other than the teacher also under scrutiny
But that's true.
by, my lord, observers, my lord, who are there in class. Now, my lord, one other, my lord, on, my lord, the legislative competence, my lord, I just wanted to show your lordships. My lord, schedule 7, my lord, part 3. My lord, earlier, as my learned friend, my lord, Mr. Dhor had submitted, this was, my lord, list 2.
Previously under the state
Yes.
list, it
And
has
my
now
lord-
been shifted from state
Yes,
to
my lord, in
concurrent.
77, 42nd amendment, my lord, to the concurrent list.
That's why I say that is
My lord, I
shifted
just,
from a
my
state
lord,
to
so this
concurrent.
is, my lord, my lord, really, my lord, the constitutional background, my lord, under which, my lord, we are, my lord, education, including technical education, medical education, and university.
This is sorry. This is
My
the
lord, 25, my
the
lord. entry 25,
Entry.
entry 25, list 3, schedule 7.
This book, I'm unable to find out the concurrent list. Yes, now got it. Entry,
25, my lord.
yes, education.
Yes.
And this was introduced in 1997,
97, my lord, 42nd amendment.
Yes.
Earlier entry 25 only related to vocational and technical
Correct.
training of labor, my lord, which was concurrent list.
Yes.
And my lord, entry 11 of the old list 2, my lord, state list, is what was, my lord, amended. My lord, kindly see, my lord, entry 11 earlier.
Yes.
I don't know if your lordship's book has it. The same entry was there, my lord, in, my lord,
This is entry 11 of,
list 2 earlier, my lord,
Earlier.
before the amendment, had the same.
no, it is not.
Is not there, my lord. Anyway, my lord, it's the same. What was there, my lord, went out from, my lord, list 2 and came into, my lord, list 3.
Because it only says that omitted. That's all.
My lord, that's
Earlier
what,
entry is not
Yes.
there.
my lord, that was there, and it said subject to, my lord, the list 1 entries, which is higher education, and, my lord, also entry 25, which was there originally, vocational training. So, my lord, in this backdrop, my lord, may I, my lord, start, my lord, the factual history, which will be, my lord, a few sentences only. Apropos, my lord, school education. My lord, most of the Supreme Court decisions, my lord, on education are, my lord, with regard to minority institutions. Most of the, my lord, leading judgments.
Pi foundations,
Yes,
then
yes,
earlier
my lord,
those judgments are.
Now, my lord, I will make a fleeting reference to, my lord, TM Pi.
That is why, not PA, TM.
I will, my lord, make a fleeting reference to TM Pi because there is one very important fact, my lord, which has been recognized apropos school education in, my lord, TM Pi. My lord, this is, my lord, 2002, 8 Supreme Court cases, page 481.
Age,
481.
Pi foundation or something like
Yes,
that.
my lord. These are the Manipal people, my lord.
Yes, that's why I know. It is started with a Frank Anthony or earlier
Yes.
judgments of our High
Correct,
Court.
correct.
It originates and then
Correct. My lord, at
they claim the minority under Article 30,
Yes,
29 and
yes.
30. They wanted to claim.
my lord, at page 551,
Para,
para 73. My lord, kindly see the heading, other aided institutions, placitum.
Yes.
Now, my lord, may I? There are a large number of educational institutions like schools and non-professional colleges which cannot operate without the support of aid from the state. All these institutions may have been established by philanthropists or other public-spirited persons. It becomes necessary in order to provide inexpensive education to the students to seek aid from the state. In such cases, as those of the professional aided institutions referred to here and above, the government would be entitled to make regulations relating to the terms and conditions of employment of the teaching and non-teaching staff whenever the aid for the posts is given by the state, as well as admission procedures. So even for higher education, my lord, terms and conditions, my lord, can be regulated, my lord, by the government. This is being recognized. Then, my lord, such rules and regulations can also provide for the reasons and the manner in which a teacher or any other member of the staff can be removed. In other
Relating
words,
to service condition as well.
correct.
Is
My
that-
lord, this is, I'm just, my lord, giving this, my lord, backdrop. In other words, the autonomy of a private aided institution would be less than that of an unaided institution. My lord, this is, my lord, the backdrop. Now, my lord, what happens? My lord, India, my lord, at independence, my lord, had not only, my lord, a rural populace, but also an urban populace. And, my lord, we have also used the expression semi-urban populace. Now, by and large, my lord, the schools which were established, my lord, were, my lord, in, my lord, areas, my lord, which were either urban or semi-urban, and were not easily accessible by, my lord, the rural populace. But, my lord, all citizens have equal rights. Now, my lord, to ensure, my lord, a more egalitarian society, that's what the landscape was. Or, my lord, schools of such nature. We had, my lord, Waqf grants. I'm talking about, my lord, other grants, my lord, which are there. But it was, my lord, the need. My lord, there was somebody, my lord, who was benevolent, who was providing for this. Now, my lord, people also have aspirations. My lord, we, my lord, earn independence. And, my lord, it's aspirational. Also, I'm looking at it, my lord, from the top is egalitarian. From, my lord, the bottom, my lord, is aspirational. My lord, for a welfare state, my lord, there has to be, my lord, both aspiration, my lord, both, my lord, objectives, my lord, has to be considered. I'm not even saying has to be provided for, I'm saying has to be considered. So, my lord, what started happening? My lord, many schools, my lord, those who were discharging benevolence, my lord, found, my lord, with, my lord, the number of people seeking education, my lord, it was no longer possible, my lord, to, my lord, run the schools themselves. So, my lord, there were approaches made, my lord, to, my lord, the state. State, my lord, had developed a policy, my lord, of, my lord, deficit grant. Whatever you cannot meet, to submit the accounts.
Just to make over the deficit.
We'll make over the deficit. Then, my lord, individual nepotism started. My lord, state nepotism, I'm not getting into. We are not concerned with that here. My lord, nepotism, my lord, started. Then, my lord, state found, my lord, accounts were not being produced. My lord, sometimes, my lord, number of children shown actually were not there. My lord, and my lord, so the state said, we must have some management rules. We must, my lord, recognize institutions. We must regulate and administer. My lord, these were, my lord, what were, my lord, thought of. So, my lord, the first piece of legislation which comes in, I've given, my lord, that, my lord, in, my lord, the compilation, is, my lord, the West Bengal Secondary Education Act 1950. My lord, apropos, my lord, the state, and my lord, I'll only read the preamble. I've given that in the compilation, my lord, which is at page 3. My lord, on 18th May 1950,
Yes. Yes.
my lord, kindly see, my lord, an act to provide for the regulation, control, and development of secondary education in West Bengal. My lord, I'm not troubling your lordship with this, but this is how, my lord, they stepped in. Now, my lord, after this 1950 enactment, my lord, we had, my lord, the West Bengal Board of Secondary Education Act 1963. My lord, Mr. Sannal's compilation, my lord, has that. And, my lord, we had, my lord, the rules for management of recognized non-government institutions, aided and unaided, 1969. So 1950, 1963, then, my lord, 1969. My lord, I am not going into notifications issued from time to time, etc. Now, my lord, this 1969, my lord, which has been given, my lord, in Mr. Sannal's compilation.
No, your compilation also have
Yes.
rules in the
But the
management
reason
of
why, my
recognized.
lord, I'm telling your lordship why I have given it separately. My lord, Mr. Sannal's is as modified up to 8th January 2010. The one I have given your lordships,
Up to 2018.
8th March 2018. My lord,
This is
those
a,
are, my lord, those two notifications I gave your lordship yesterday.
yes.
My lord, those are, my lord, my lord, till that date. My lord, 8th of March 2018. My lord, I'll deal with those provisions. So, my lord, this is how, my lord, it develops. Now, my lord, first submission, my lord, which I make before your lordship is, the state, when undertaking its constitutional obligations, my lord, has, my lord, decided to, my lord, do so either by, my lord, it's a rule-making power, or, my lord, a plenary piece of legislation. My lord, that's what was happening. Then came, my lord, my lord, 19. No, my lord, I must point out, lordships put a query yesterday about who pays pension. My lord, we had the West Bengal recognized non-government educational institutions employees death cum retirement benefit scheme 1981. My lord, that's at page 65. And, my lord, I have given it, my lord, your lordship will find that, my lord, it starts, my lord, I've given it, my lord, from, my lord, kindly take the bottom pagination, my lord, from 15th of May 1985. This has been the position. And the scheme, my lord, which is referred to, my lord, in, my lord, this memorandum, my lord, your lordship will find, my lord, these are all after, my lord, a 309 exercise. My lord, the recommendations come in, they concern, my lord, government employees as well as, my lord, what is happening, my lord, in, my lord, institutions discharging public functions. So a 309 exercise, my lord, is done for government servants. Then, my lord, for, my lord, others who are discharging public functions, my lord, the schemes are framed on the basis of recommendations of pay commissions. Now, my lord, this scheme, my lord, your lordships will find is, my lord, the pension, my lord, which is provided and government pays it. My lord, I don't think there is any dispute, my lord, with regard to that. In fact, DNS allowance as well. My lord, my lord, when we calculate the figures for DNS allowance, my lord, and our state does it, many other states don't have it. My lord, at government level, your lordship's question, my lord, on pension, DNS allowance, my lord, for, my lord, teachers. All governments, my lord, all state governments don't do it. West Bengal does it. We are talking about several thousand, my lord, several thousand crores when we start talking about it, my lord, and double-digit thousands. My lord, it includes not just government servants, my lord, it includes, my lord, all, my lord, to whom, my lord, the same, my lord, facilities, my lord, are made available as, my lord, government servants. And that includes, my lord, the teachers, my lord, in schools.
Of a aided
Aided.
and a sponsored.
Correct. So, my lord, DNS allowance, pension, my lord, all career advancement scheme. Lordships had occasion, my lord, to look at that in the 3-judge, my lord, matter, my lord, where I had concluded, my lord, of, my lord. I'd given all the, my lord, compilations there. So, my lord, this was, my lord, the, my lord, position which is happening. Now, my lord, pausing here, my lord, before I come to, my lord, the 1997 Act, my lord, I wanted to show your lordship the bill. Now, my lord, here, my lord, we have, before 1997, my lord, my lord, teachers have been put at par, my lord, in terms of emoluments to, my lord, government servants, in the sense of the rights, pension, my lord, DNS allowance, which scale and all I'm not going into, but these are, my lord, what is being provided for. So, my lord, what happens now is, my lord, in appointments, my lord, government is looking for a larger role. That's how 1997 comes in. Now, my lord, even before that, my lord, kindly take Mr. Sanyal's, my lord, compilation. I want to show, my lord, 1969, my lord, regulations which were handed up.
Yes, management rules. It is
Correct.
again modified up to 8 January 2010.
Kindly come to page 56, my lord, of that compilation.
Power of the committee.
Correct. Power of the committee. Now, my lord, kindly come to page 60 before I place 58.
Page
60, 60, my lord, 60.
Yes.
My lord, kindly see the note, second note at the top.
Yes.
Because, my lord, an aided institution
Yes.
is not defined in these rules of 1969. So, my lord, what they do here, my lord, is they say an institution receiving recurring financial assistance in a,
You defined aided institution. Actually, you define
Correct.
aided institution. You say any institution
correct. But, my lord,
receiving money for maintenance, payment of salary
anything.
or
My lord, is much wider. My lord, what I wanted to tell your lordship is much wider than what is there in 1997 Act.
Correct.
Kindly see. an institution receiving recurring financial assistance in any shape or form from the state government, either for maintenance or for payment of salary and or allowances of teachers and other employees thereof, shall be treated as an aided institution for the purposes of these rules. Now, my lord, kindly have a look, my lord, at my lord, powers of the committee. My lord, first point I wish to make, my lord, is, my lord, the, my lord, proviso, my lord, which, my lord, comes in, shall have the power, my lord, 3-1, my lord, 28-1I. 28-1I.
Yes, to a point.
Yes, my lord, kindly see, my lord. This, my lord, came in, my lord, in 2010.
Correct.
To appoint, subject to the provisions of sub-rule 1A, teacher on the recommendation of the West Bengal Regional Service within local limits of the jurisdiction in which it shall exercise its functions under West Bengal Service Commission Act 1996, provided that where the committee is not in operation or existence and where no administrator has been appointed for reasons of pendency of any legal proceedings, the head of the institution shall, with the prior approval of the concerned district inspector of schools, appoint such teacher on behalf of committee or administrator as the case may be, and the committee or administrator shall, whenever start functioning, by an order ratify such appointment. So, my lord, first appointment is on the basis of recommendation. This is before the 2017 amendment. So, my lord, appointment has to be done on the basis of, and then, my lord, where, my lord, the committee is not in operation, then, my lord, approval, my lord.
Head of the institution, he can,
Yes,
with the
he
prior
prior
approval of the
and,
DI.
and the committee or administrator shall, whenever it starts functioning by an order, ratify such a point. Then, my lord, kindly see 1A to 1C. My lord, 1 subclause 1A, 1B, 1C, my lord, which are, my lord, mentioned, to appoint in accordance with the directions given by the director. And director is director of school education, defined. So as per, my lord, so, my lord, kindly see, my lord, what all is happening. Behalf teachers to appoint in accordance, if available, within the sanction strength, to appoint so-and-so assisted against vacancy within sanction, to appoint in accordance with directions given by so-and-so, to engage out of Sarbo Shikha Abhiyan Fund, para teachers, so-and-so. Then, my lord, I'm not troubling your lordship with non-teaching staff, which is 2. My lord, 1 clause 2. My lord, I'm not troubling your lordship with that. Now, my lord, kindly come to, my lord, 1A at page 57. Save as otherwise provided in the proviso to clause 1 and 2 of sub-rule 1, after appointment of the teacher or non-teaching staff, including librarian, is made under sub-rule 1A, the committee shall ratify such appointment in its next meeting and shall forward within 15 days from date of such ratification all documents relating to appointment to the director or any officer authorized by him for verification, as well as for granting post facto approval of the appointment from date of joining. This has to be done. Then, my lord, the director may, after verifying, issue post facto approval. If the officer authorized by the director does not approve of the appointment or extension of so-and-so, as the case may be, he shall refer the case to director, and in the case of disapproval of any appointment or director, officer, author shall communicate reasons. Then, my lord, consequences, my lord, are given. Kindly come to 7, which my learned friend, my lord, also relied on. In all cases of appointment, both permanent and temporary, the committee shall issue letters of appointment specifying terms and conditions of such appointment. In the case of a permanent appointment, a teacher or an employee appointed on probation shall be confirmed on expiry of period of probation, unless an order to the contrary is issued at least 6 weeks before the date on which confirmation normally falls due. In the case of an appointment on temporary basis against a permanent post, teacher so shall be confirmed on completion, so and so, provided that no appointment shall be made in a vacancy if it is not against a sanctioned post, permanent or temporary. Then, my lord, kindly take 9, my lord. At page 59, 28(9). In aided and unaided institutions, committee shall have the power to grant leave, etc., manage funds, etc., to suspend teacher, etc., etc. Then, my lord, in 7A, kindly see, suspending a teacher or an employee, etc., kindly see, my lord, 5 lines. Such steps shall be referred to the board within 7 days of such action for approval. Person affected by decision of the committee may, however, make his or her representation to the board. Order of suspension shall automatically stand withdrawn in case proceedings are not drawn, provided that in excess this time limit may be waived after due consideration, but under no. Then, my lord, kindly see 28A at page 60. So, my lord, grievances regarding, my lord, punitive action by the committee against teachers could go, my lord, to the board. Now, my lord, kindly see, my lord, 28A at page 60. Notwithstanding anything contained elsewhere in these rules, state government shall have the right to proceed against any member of the committee who, in the opinion of the state government, commits financial irregularity or acts against the interests of the institution.
No, what it was argued by them that look, by virtue of these act and the rules which are framed, the power is actually vested upon the board, or at best the board now, which they disputed that the effective date has not been notified.
But that has,
But it is all along a committee which was entrusted with those powers.
yes.
So if you have this power has been delegated or it is conferred upon them, how can a state usurp
Yes.
and take over
Yes.
everything? That was Mr. Sanya's
Yes. Now, my lord,
take over
yes.
and then say that I will do it.
Yes. Now, my lord, what I'm first submitting is joining issue with my learned friend on the interpretation of the very rules he relied on.
Yes.
And, my lord, why do I join issue? My lord, I've shown your lordships, my lord, that several appointments, my lord, require, my lord, have to be made on the directions of the director of school education, who comes under directly, my lord, the state department. Second, my lord, post facto approval for appointments are also required, my lord, by the board. Third, my lord, if, my lord, any, my lord, punitive action is taken, then, my lord, board can entertain, my lord, a representation from, my lord, the teachers. Cannot happen, my lord, at, my lord, the ipse dixit, my lord, of, my lord, the committee. And, my lord, the, my lord, accounts, my lord, reporting, etc. also here, my lord, I'm not going to trouble your lordship with those, but I'm, my lord, mainly on, my lord, my lord, these powers of appointment. Now, my lord, this was straight after the act came in, and what has been added, I have also, my lord, shown your lordship pursuant to 1997. Now, my lord, in this context, our High Court, in a division bench judgment, I'll cite 2. My lord, considered, my lord, what was the nature of service, what was the nature of employment of, my lord, school teachers. And this is before the amendment of 2017. Because, my lord, state is taking over, discharging, my lord, obligations, my lord, constitutional obligations, duties, to provide for, my lord, a more egalitarian. My lord, at the end of the day, it's a case of opportunity, my lord, for, my lord, the students, for the children, so that we may at some stage, my lord, achieve, my lord, an egalitarian society. Now, my lord, kindly have a look at, my lord, the 2 cases. My lord, My lord, the first decision, my lord, is reported in 2008, 1 Calcutta High Court notes, page 582.
Yes.
My lord, many appointments, my lord, I'll tell your lordship the issue involved here and then show the passages. Many appointments of teachers had happened without following due process. My lord, there was regularization of such appointments that was challenged. Argument was, when, my lord, the challenge was made, that, my lord, Uma Devi's case does not apply because those all related to public employment. Uma Devi's case, my lord, regularization, backdoor entry related to, my lord, public employment. Now kindly have a look at what, my lord, the division bench had to say. My lord, paragraph 20 at page 595. The next submission made by the learned advocate of the respondents' writ petitioners is that the judgment of Uma Devi was delivered by the Supreme Court in the light of public employment. In the said case, the government servants were claiming regularization. The managing committee of the school does not come under Article 12 of the Constitution. Kindly, my lord, see. A teacher who gets an appointment in a school cannot claim that he's a public servant or is being given a public employment. The employment as a teacher is not a public employment within the meaning of Article 309 and 311 of the Constitution. Now, my lord, but such an argument cannot be accepted by us. Conditions of service of approved teaching and non-teaching staff of a recognized aided institution are fully spelled out by the state through the 1969 management rules, which is by way of subordinate legislation. Every step is to be done as what has been spelled out by the government, subject to approval of West Bengal Board of Secondary Education, which is another limb of the government. How and in what manner these teachers and non-teachers are to get leave has been spelled out in Rule 28.9. How an approved staff is to be suspended has been spelled out by the state in Rule 28.9 6A. Salary grant of the teaching and non-teaching staff and non-salary grant concerning education institution are entirely borne by the state. Non-salary grant includes building allowance, midday meal expenses, hostel development funds for backward class schools. After any teaching and non-teaching staff retires, terminal benefits of the retired employee is paid in terms of a pension scheme which has been formulated by the state. The financial assistance from the state in these institutions is so much as to meet the complete and entire expenditure of the institution. In other words, these recognized, aided educational institutions in West Bengal are imparting education as the, kindly note, education agencies of the state and are trying to fulfill the constitution obligation of the state contemplated in Article 45 of the Constitution of India. Well, this was before the amendment. Functions of such recognized aided institutions are of public importance and related to governmental functions. It is clear that there is existence of state control so far as approved employees of any recognized aided institution are concerned. In such circumstances, it cannot be said that the teachers and non-teachers of a recognized are not in public employment. The lordships have delivered judgments, my lord, regularly. My lord, on, my lord, recruitment matters. Your lordships are being approached. It's not purely contractual, then, oh, it's management committee.
Yes.
Now, my lord, if this was the position, I'll, my lord, now give your lordships, my lord, an earlier judgment. Earlier. My lord, of my lord, I think it is earlier, at least it's, my lord, reported in a, my lord, few months
The
earlier.
date is 14th of
September.
September 2007, and which
Yes.
one?
Now I'll give your lordship a later judgment, my lord, 7th of May, 2008. Also division bench, which, my lord,
Reported in?
my lord, it's reported in, my lord, 2008, 2 Calcutta High Court notes. अरे flag तक ही दिख चुका है।
Page?
My lord, page, my lord, 994. My lord, I'll tell your lordship what had happened.
Yes.
Sir. Transfer provisions, my lord, 10A, 10B had not come in.
Not coming.
Had not been, my lord, engrafted.
Okay.
Now, my lord, certain teachers wanted a transfer. For my lord, fortunately, my lord, it was a case of mutual transfer. My lord, ground was families were away. My lord, they needed to be near their family. No transfer provision. So the question arose, so my lord, but in the meantime, in several cases, writs had been entertained for mutual transfer. Orders had been passed. The DI, my lord, to consider the representation and pass orders. In some cases, orders were passed. In this particular case, it had been refused. Second time round. After, my lord, first attempt, go back, consider representation, reasoned order refused. Single judge rejected the writ petition, saying there's no power of transfer. Can't. Now, my lord, came to the division bench. Now, kindly have a look, my lord, at my lord. Page 997. My lord, is, my lord, where the judgment starts. My lord, it gives the history, what I've indicated to your lordship. Oh, I'm sorry, my lord. I'll give your lordship, my lord, the paragraph numbers. My lord, para 1 to, my lord, 7, my lord, is, my lord, 1 to 6, my lord, are, my lord, the facts. Kindly come to para 7. Lord, I'm told the copy which your lordships have, my lord, has the PDF page, but not, my lord, the page number of the report. Para 7, does it start, my lord, in any event?
Any event, yes.
In any event, after commencement of West Bengal School, appointments are made by concerned managing committee on recommendation, function of school service commission. Kindly notes this. Comes to an end immediately after sending recommendation to the school concerned for appointment to the post of teachers. In the present case, undisputably, both the appellants were appointed so and so by duly constituted of and the recommendation. Schools are under no can retain any authority or jurisdiction over teachers concerned after recommending their name. Therefore, in the present case, school has no role to play. Under extraordinary and compelling circumstances, appellants being teachers of two, prayed for mutual transfer and managing committee of so and so agreed to oppose it and passed a specific according to director of West General, and therefore the same does not deserve so and so. Then, my lord, examine rules, my lord, are examined at para 11, kindly the order. Then, my lord, para 12. The School Service Commission is bound to evolve a policy for recommending the candidates to respective posts of teachers for appointments. However, subsequently, if two teachers suffering due to their appointments in the schools concerned decide to minimize their sufferings by way of mutual transfer, then the state government is the appropriate authority to come to the aid of the teachers, and the competent authority of the state government is entitled to issue appropriate directions upon appreciating the compelling need of teachers under special circumstances, even in absence of any express provision of law. Since the competent authority of the state government has
Nodal employer.
well, show your lordship. This is what it is in reality. Has inherent power and authority to issue such direction in an appropriate case. Furthermore, in the discharge of its functions, the School Service Commission is guided by directions as are issued to it by state government from time to time. The competent authority of the state government, namely
Service is under the
Cannot-
control of the state government.
yes, who were appointed. Though it was selected by and appointed by manager, yet after appointment, their service is under the control
This is what
of
I
the
say.
state
Now
government
this time I am
and the state-
faster than you.
No, no, right, my lord. I am, my lord, also reading, my lord, to put emphasis, my lord, so that otherwise, my lord, I had, and now your lordships notice, my lord, I am marking, my lord, in pencil, one color with, my lord, sides. Because, my lord, as far as briefs are concerned, my lord, I'm having to, no, I, my lord, have either a soft copy or, my lord, I'm not being able to read the briefs. I am, my lord, just taking down notes on what the matter is about. Then, my lord, kindly see, my lord. In a welfare state, the state government should play the role of model employer and should not act as an autocrat, quite unmindful to
This
the
is what I
difficulties
say,
of-
model employer.
Yes. The fact that a teacher has been appointed and posted in a particular school does not permit to be callous to the difficulties which are being faced in his, and thus to sacrifice the genuine case in the altar of unjustified and so on. Then, my lord, your lordships had put a very important question. My lord, 3 documents were shown by Mr. Sanya. One of them had transfer over. Other 2 did not have. Lordships asked a question. Does the act have a prohibition? Do the appointment letters have a prohibition? No. It's neutral on that. Now, my lord, kindly have a look at para 16. My lord, middle of, my lord, para 16, the state, my lord, about 10 lines from the state
The state government
respondents
herein are
only required to record the mutual transfer of petitioners herein in order to keep the records in order. In the event the prayer made on behalf of the appellants for mutual transfer is given effect to, then no statutory provisions will be violated. There is no provision in law which prohibits, and this is after coming into, my lord, the 1997 Act, but before transfer provisions, the aforesaid mutual transfer. In the absence of any statutory prohibition, aforesaid mutual transfer is permissible, especially when such transfer will not benefit the respective teachers, but not only benefit the, but will also benefit the schools concerned and ultimately the students concerned, and the teachers would be able to discharge their duties in a peaceful mind in view of such mutual transfer. Then kindly take para 19. It is true that relevant rules guiding service conditions of teachers in secondary schools do not expressly provide for mutual transfer. It is also true that mutual transfer is not prohibited under the rules or by any statute. When the grievances are not unlawful and unjustified, courts of law are not helpless in granting equitable relief so and so, and therefore cannot refuse to consider the grievances of further purpose. The grievances of petitioners here are not at all unlawful and unjustified. Mutual transfer will benefit the petitioners. They will be in a position to serve the respective institutions with more vigor and peace of mind, obviously not being haunted by hazards of attending school from that is sacrificing peace. Teachers concerned will get. So not only in the interest of teachers, but also in interest of proper education in school, mutual transfer must be accepted, especially when other teachers would not suffer any prejudice. So will also not suffer in any way and will not be burdened with extra financial liability. Therefore, in order to do substantial justice, etc.
So this is how they say, if it is not, disadvantageous or suffers any commit or causes any prejudice or injustice, then there is no difficulty. That's an acceptable.
No, my lord, I am more on, my lord, there being, my
There's
lord,
no prohibition.
and my lord, 10A, 10B were not there then.
Not there.
There was no bar. 10 was there,
That is what it says, disadvantageous.
and 10 was there.
So in 10, that was considered to have imbibed within itself the concept of transfer.
Correct. Now, my lord, what is very important, my lord, is, my lord, first, my lord, apropos, my lord, transfers, my lord, is inherent power. So, my lord, state, my lord, had the power to solve, my lord, the situation, my lord, by transfer. So, there is an inherent power to transfer. Second, my lord, there is no statutory bar, no subordinate legislation bar, no bar in contract. None has been shown. But third and most importantly, they are treated as government employees. And 2 division benches have held, my lord, that it's part of public employment. And after considering the factual situation, my lord, your lordships were cited a case that, my lord, the veil can also be lifted to see if it's a colorable exercise of legislation. My lord, the true facts, my lord, in court can show, my lord, whether it's public employment or, my lord, purely contractual, school specific. My lord, everybody, my lord, once it's public employment, my lord, it's a question of status. They are also discharging public good, the teachers. They deserve the highest respect. I don't say that. So, my lord, if a transfer is malafide, please strike it down. I'm not saying, my lord, states' actions are immune. But we are, my lord, concerned with, my lord, the
Power of the state to
yes. Now, my lord, if it has
incorporate,
inherent power,
then by
my lord,
virtue of a legislation, piece of
it has
legislation.
to have that power. Manner of exercise of the
In
power.
order to bring more clarity, fairness and transparency into it.
Yes. And, my lord, if I, my lord, discharge even as abuse even a statutory power, a valid power, my lord, court is available. In fact, my lord, there is also, my lord, an internal provision here, my lord, which I cited on the first day, Regulation 7, that if you are upset with a particular transfer order, you have a grievance, there is a dispute, there is a redressal mechanism. But I'm not saying for a moment, my lord, that it cannot be challenged, the exercise of the power. But, my lord, conferment of power, where there is already inherent power as recognized by the courts, and there is no statutory bar, then, my lord, in my respectful submission, my lord, there can be no objection, my lord, on any of, my lord, the grounds. My lord, whatever comes under Article 13, my lord, and what has been argued, my lord, personal inconvenience, my lord, generally, my lord, is not a ground. Generally, my lord, I am not putting my case too high that it can never be. My lord, there was a case where a blind teacher had been transferred. My lord, recommendation. My lord, I've said that has to be withdrawn straight away. Then, my lord, cancer patients, my lord, who are undergoing, my lord, a routine therapy.
These are all, the reasonable approach to an issue.
Correct.
In exercise of a statutory power which is conferred upon
Correct.
it.
That's the exercise
Here
of
is
the
a
power.
case, here is a case whether the statutory power can be conferred or can be usurped or can be created.
I'm grateful.
That's why on the very first day I also said rather that we will not enter into the merit whether
Yes.
it is a
My lord, that's,
malafide
my lord,
or something,
my lord, that's the,
because that's not an order of reference
that's, my
also.
lord, the order as well, my lord.
Is not. So it is only on the touching upon the, I would say, the validity, invalidity of
Correct.
section 10C. True.
That's how, my lord, my lord, look at, my lord, my lord, your lordships have a midday
Yes,
break, my lord. My lord, kindly take 5-10 minutes, my lord, I'll come back also. and what your lordships observed regarding, my lord, disadvantageous phrase, my lord, appearing in section 10. My lord, I just want to straight away cite, my lord, one Supreme Court decision reported in 1968, 1 SCR 185.
On what proposition?
My lord, really, my lord, a government employee, then my lord, it's a question of status. And my lord, there can also be unilateral, my lord. My lord, paragraph 6, my lord. At PDF page 9. My lord, about 10 lines from the start, but once appointed to his post or office, the government servant acquires a status and his rights and obligations are no longer
Yes,
determined.
yes, yes. From where? From where?
My lord, it starts, my lord, about, it is true that the origin of government service is contractual. Your lordship has that.
Just 1 minute.
About 10 lines from the
Yes,
start
I
of.
got it. Yes, it is true that the origin of the
There is an
government
offer
service
and
is
act, but once
contractual.
appointed to his post, acquires a status and is no longer determined but by statute or statute which may be framed and altered unilaterally. Now, my lord, if he's in government service, it's an incident of service itself. The transfer.
This is too fundamental. Origin is always,
Yes,
he has been offered, he may refuse that I will not join.
yes.
Line about 7 or 8 from the bottom is important, you want to say.
My lord, the 5-judge bench, 2 judges from Calcutta High Court,
It says the
and my lord, the
first thing is
surname common with,
emolument of
correct.
the government servant and his terms of service
Correct.
are governed by the statutory rules, which may be unilaterally altered.
Correct. My lord, there are several reasons.
Because that was argued that it can't be. It's a
Correct.
contract.
Correct.
It's a bilateral act.
Correct.
Can't be unilaterally varied or altered.
Your lordship seen, my lord, 2 from our court, and my lord, the other is the surname, my lord, of one of the litigants.
Ah, that has been relied in a subsequent
Yes,
judgment.
lot
also.
of, my lord, this is one of the lead cases, my lord. What I'm trying to show your lordship, my lord, is how short, my lord, those, my lord, judgments were. Now I get lost, my lord. Now, my lord, so, my lord, now, my lord, I come to, my lord, that compilation, my lord, which I have
Now you
handed.
are privileged.
Beg your lordship.
Now you are privileged.
Oh,
Yes.
my lord, at least my learned friend comes sometime. When the names appear, my lord, there are many other than him. Now, my lord, kindly, my lord, take, my lord, the, my lord, amendments, my lord, page 93 onwards, my lord, of that compilation. In fact, my lord, I should, my lord, indicate, my lord, before that, my lord, section 10 was there from the beginning as far as teachers were concerned. That your lordships will find at page 93 of, my lord, this compilation which I've handed up. Then, my lord, that was, my lord, further amended, my lord, in, my lord, 2008. 2008. My lord, page 121, my lord, your lordship kindly sees. Where, my lord, several amendments were made, including, my lord, to section 10, my lord, at page 123. Section 9 of the amending act, my lord. My lord, non-teaching staff, my lord, was also included. That's how it
Yes.
stands at present. Then, my lord, is, my lord, the 2010 amendment. My lord, that's when, my lord, what, my lord, Mr. Thor refers to as the family. My lord, start, my lord, of the family of section 10. But which your lordship will find, my lord, at page 93.
Page,
93, my lord. I'm giving your lordships the bills first, my lord. The act your lordship seen, my lord. This by this, my lord, section, my lord, 10A, my lord, mutual transfer was introduced. My lord, kindly see the statement of objects and reasons at page 94. It is considered necessary and expedient to amend the West Bengal School Service Commission Act with a view to empowering the West Bengal Central School Service Commission to make recommendation for mutual transfer of so and so. Then, my lord, kindly take, my lord, the 2013 amendment. The bill, my lord, statement of objects. Kindly come to page 98. 97 it starts of the compilation, page 98. My lord, at the bottom, statement of this 10B comes in. It is considered necessary and expedient to amend the West Bengal so and so with a view to empowering to make recommendation for general transfer. So it's again empowerment of, my lord, the commission. Then, my lord, the act, my lord. So this was 2013. Then, my lord, the 2017 amendment, which introduced, my lord, 10C. Kindly have a look at the statement of objects, my lord, page 107. Oh, sorry, my lord, 102. I'm sorry, my lord, 102.
no, I am looking at 102. Don't worry.
I'm sorry, my lord. 102. Kindly see, my lord. It is considered necessary and expedient to amend the West Bengal School Service Commission Act for the purpose of empowering the board, namely West Bengal Board of Secondary Education, in place of managing committee or ad hoc committee or administrator of any, where there is no managing in relation to a school under the act, with powers to appoint teachers and non-teaching staff on the basis of right made by West Bengal, and to effect transfer of teachers and non-teaching
The
staff.
most important is after B.
In order to rationalize pupil-teacher ratio in such schools for maintaining quality education, with a view to enabling the state government to take appropriate action as it may think fit and proper to ensure healthy educational environment. This was the purpose. Lordship wanted to say it, my lord. This is important, and my lord, it's even more important, my lord, to now notice, my lord, the Control of Expenditure Act, and my lord, two other documents. My lord, West Bengal School Control of Expenditure Act 2005, kindly come to 112. This is, my lord, before, my lord, its amendments. Kindly come to section 12. If the state, sorry, at page 116. If the state government has reason to believe that number of students studying in a particular school has fallen below the prescribed number, or, my lord, your lordships, my lord gave an example, my lord, aspiration.
That was hypothetical. That was out of box.
No, but that's
That was
exactly,
thinking.
my lord. Now kindly see, or the school authority has failed to take action as directed by the state government under section 11. It may, after giving the concerned school authority an opportunity of being heard and for reasons to be recorded in writing. My lord, kindly take C. Order shifting of teaching and non-teaching staff from such school to any other school within the region. The statutory provision made, my lord, in 2005. And my lord, 16 was similar to 10, which had been placed, my lord, before your lordships yesterday. Notwithstanding anything contained, that's at page, my lord, 117.
B is also there. You can abolish any teaching or non-teaching
Correct.
post of the school.
Correct. I can do that also. I can say that post will be somewhere else where it's, my lord, filled up.
Yes.
And my lord, this act was also amended. My lord, kindly come to, my lord, page.
He was referring section 16.
Yes, 16 is same as 10, my lord, which your
10.
lordship had pointed. Then, my lord, 157, my lord, there was an amendment, my lord, introduced.
One.
My lord, page 157. My lord, kindly see 5, section 5, which was, my lord, a 2017 amendment.
Void appointments.
Shall not appoint teachers in contraventions of this act, rules, orders are issued.
This came in 2017.
This is 17. But my lord, that transfer provision has been there, my lord, from, my lord, the beginning. And now, my lord, kindly have a look at, my lord, staff pattern. My lord, page 119.
Yes.
My lord, this is distribution of teaching staff in recognized non-government junior schools, so and so, whereas.
Can't you have a typed copy?
My lord, I'll get one, my lord. This was a copy, my lord, which I'll replace it, my lord.
Yes.
I'll get it. এটা আজকে তোমরা type করে দাও।
Which one you want to?
My lord, it's kindly see, my lord, what it's, my lord, this is in 2016. My lord, after, my lord, the Right to Education Act of 2009.
Reallocate the all existing sanctioned vacant post of the teacher in the high school higher.
Reallocate all existing sanctioned posts so and so in the following manner. So, my lord, if reallocation is also taking place, my lord, what your lordships pointed out in 12B. My lord, this is the staff pattern distribution. Classes 5 to 8 of junior high school language group 2 posts. My lord, who will be past graduates. Science and mathematics 2 posts, past graduate for these classes. Social science group 2. And my lord, in each class, if I'm not mistaken, there have to be, my lord, 40. 1:40. That's the ratio. Then, my lord, kindly see 9 and 10. Language group 2 posts, postgraduate. Science and mathematics 1 post, past graduate. In secondary school for classes 5 to 10, physical education, etc. So this is a staff pattern, my lord, which has to be maintained. Over and above that, my lord, kindly have a look at now, my lord, section, my lord, 25 of the Right to Education Act. I believe a copy was given, my lord, yesterday.
এই কালকে যেটা দিয়েছেন হ্যাঁ ও yes taken back.
I thought it was there, my lord. I'll otherwise include it, my lord. Copy আছে?
Give a copy.
আছে। আছে, আমার কাছে আছে।
Section,
My lord, 25, my lord.
yes. Why? Oh, this is the rule, sorry.
My lord, within 3 years from date of commencement of this act,
Yes.
appropriate government and shall ensure that pupil teacher ratio as specified in the schedule is maintained in each school. For the purpose of maintaining pupil teacher ratio under subsection 1, no teacher posted in a school shall be made to serve in any other school or office or deployed other than those specified in section 27. My lord, then prohibition on deployment for non-educational purposes, prohibition of private tuition by teacher. This is all, my lord, for egalitarian society. And my lord, kindly see the schedule. This is,
Up
my
to
lord,
62, between 61 to 93.
up to 62, between 61 to 93. My lord, this is for first to 5. Between 91 to 120, 4 between 100, so and so 5, 5 plus 1 head teacher, above 200. My lord, it's all given here. My lord, in fact, I must tell your lordships, my lord, there is still also a public interest litigation. My lord, on, my lord, this, my lord, whether this act, my lord, is being followed or not. So, my lord, we have submitted, my lord, the state, it's one of the first matters that I did, my lord, a full compilation, my lord, of, my lord, all the aided schools, government schools and sponsored schools as to whether this was being followed or not. And, my lord, there was a discrepancy in a few. Court, my lord, has also requested us to frame a policy. And, my lord, one policy, of course, has been framed, my lord, which is now, my lord, before your lordships as well, to try and ensure that this also happens. So we have a staff pattern as well as this. Now, my lord, I now, my lord, put, my lord, a question to myself in the form of a submission. Now, my lord, let us examine, my lord, 4 or 5 scenarios. My lord, recruitment has happened against, my lord, sanctioned posts. One set of recruitment, in every high court it happens. My lord, has been made subject matter of a litigation. My lord, for far less exciting grounds than what are pending in our high court. And, my lord, there is, my lord, a stay. Because there is a stay to the recruitment process. Now, the recruitment is done against certain number of vacant spots. My lord, that is state, it has not been filled. In the meantime, my lord, schools are dynamic in terms of population by, my lord, students. My lord, in some, my lord, the population might have increased. In some, they have decreased. And, my lord, more vacant posts, my lord, have, my lord, come up. Now, my lord, here, my lord, if we have a situation where, my lord, school, my lord, is offering, my lord, a science course and a mathematics course. And, my lord, we do not have teachers for that, but we have a subfield for language. And, my lord, here, my lord, the constitutional obligations are being discharged, and we are aiming at an egalitarian society. Kindly look at the reality of the situation in the ground. My lord, can it be said that the state will have no power to, my lord, transfer? My lord, our division bench has said it has inherent power to rectify a situation. Now, my lord, when it, my lord, decides to, my lord, have statutory power, to confer itself with statutory power, or the state is conferred, the state doesn't confer itself, is the legislature, which confers on the state a statutory power. Question would arise, my lord, whether, my lord, that can be struck down. My lord, with the greatest of respect, my lord, keeping in mind, my lord, the objects, my lord, of the sought to be achieved by the basic structure of the constitution itself and constitutional provisions. With the greatest of respect, my lord, I say that cannot happen. That's my most humble and respectful submission before your lordships, my lord. And I would request, my lord, the teachers, my lord, I have seen, my lord, village teachers over years, my lord, be such an important member of society. But that localized, my lord,
I do not consider them as, certainly they are one, but I consider them as the first
correct,
pedestal,
correct.
because the first interaction, both
Yes,
mental,
correct.
physical,
Everything.
intellectual, that it starts from them. And that's why even in a Vedic age, the
Absolutely.
role of a teacher
Yes.
or a guru, we call it, has already been recognized by all these philanthropists,
Yes.
the philosophers, the saints,
Everybody.
the
My lord,
rishis.
My lord, in fact, in almost every stream of thought, my lord, if we look at, my lord, Greek philosophy, even, my lord, the ancient, my lord, we look at Indian, we look at Greek, let's look at ancient civilizations. My lord, stream of thought, my lord, Plato, Aristotle, Socrates, the Oracle of Delphi, my lord, is quoted even today. My lord, there's a beautiful book, my lord, took me a lot of time to, my lord, go through it. My lord, Eastern Religion and Western Thought by my lord, Professor Radhakrishnan, my lord, he was, my lord, in Oxford also.
Great teacher.
Yes. So, my lord, it's my lord, teacher's role, my lord, is, my lord, really important. My lord, it shapes character. Yes, my lord, when state, my lord, has taken over, my lord, its object is to have a more egalitarian society. My lord, I remember, my lord, when we were in Presidency College, my lord, there was an objection to transfer of teachers from there, saying at the end of the day, the process of admission is through competitive examination and school results. And the best students come here because you have the best teachers. Left front said, sorry, no. Even the poor students should have the benefit of, you cannot have elitism in colleges. So the counter argument to that was, you have to have elitism in higher education, in that sense. If somebody is good in merit, irrespective of background, must have. And once you have that,
What was the purpose of this introducing this counseling system in the employment? I can admit or accept so far as this system in an admission of a educational institution.
my lord, which we had to face, whether we'll get IIT Kanpur or IIT Kharagpur, for, my lord, because
The choice has to be left. with
yes,
the
and
student.
choice of subjects, my lord, that was what we
True.
had to face.
Then why
Institution and
it
subjects.
was introduced for employment?
But, my lord, even that,
What was a rational or a purpose or
I haven't,
object? But
I
you have
haven't,
introduced.
my lord, I really, my lord, I can ask, my lord, Mr. Bhattacharya, my lord, on Mr. Bikash Ranjan Bhattacharya. Started with that.
That was done.
But I think so, my lord, 2007 hi to chilo.
No, it is done very recently, I believe,
No, there was, my lord, both. There was, my lord,
or since 1997. After this school service commission was.
my lord, after
Take place.
1997 also, my lord, there have been till 2010, my lord. 2007. My lord, school service selection of persons for appointment rule 2007. My lord. My lord, Rule 17. My lord, and my lord, Schedule, my lord, 4. You can answer. Schedule 4, Clause 5, my lord. Actually. Schedule 4, Clause 5. That happened in 2007.
Oh, I can understand so far as this, even a central legislations, there are many services. But those were the choices as to the reason or the state was sought. That if it is the all India service, which state you chose to be there. Like in IAS also,
Yes, my lord, it's,
they seek the preference that in which state
yes.
you wanted. I can understand to that extent, but particular school and they are contending that the moment you have introduced this system,
My lord,
that means that if I have chosen a particular school, how can I be later on within a span of 1 month, 2 months, be taken off from that school? Obviously, you may say it's a question of prejudice, it's a question of malice, it's a question of malafide, which would be judged on a basis of a case-to-case basis, on a case-to-case basis. But still, it has some kind of an impact.
my lord, if it's a government service, my lord, no impact. None. None at all. And my lord, there's no bar, my lord, on transfer. My lord,
No,
on
no,
my
that's true, that's true, that's true.
My lord, I think now, my lord, with the constitutional obligations, my lord, school centric, my lord, has to be, my lord,
Done away with.
cannot be, my lord. Otherwise, my lord, I have a copy of the debates. Not worth it.
Not.
My lord, just slang match going on. My lord, my lord, have it in Bengali. My lord, how it was recorded. My lord, which I got hold of, and I have also got a Google Translate of that.
No, no, it's not
lord,
necessary.
it's not worth it. I
I
read
can
it.
read faster than you.
No, no. May or may not.
May.
But my lord, it has not, my lord, it's not worth reading.
But only difficulty in reading it when it is in a handwriting and a bad handwriting.
No, it's not bad handwriting, my lord.
It's the typed one.
Yes.
So typed one, no problem.
My lord, in fact, good handwriting is more difficult to read, my lord. I used to find, my lord, Mr. Somnath Chatterjee, he had a beautiful handwriting. And whenever he wrote, whether in English or, my lord, Bengali, my lord, particularly his Bengali handwriting, my lord, was, in fact, both his daughter's wedding cards, my lord, were handwritten by him. It was literally calligraphy, my lord, his handwriting. And my lord, any letter that he wrote to my parents, my lord, the handwriting was always, particularly, my lord, when both were in, my lord, the political sphere. My lord, whether in English or in Bengali, my lord, it was.
Yes, that's all.
So, my lord, I now, my lord, just want to deal with that retrospective. My lord, first I say if I'm right in all the submissions that I've made, my lord, that argument doesn't come in at all. Now, my lord, the retrospective, the cases which have been cited, my lord, no right which had vested, my lord, has been taken away in the sense, it's real retrospective is, my lord, if, my lord, that vesting, my lord, is interfered with in the sense of, my lord, saying, my lord, it never vested. But, my lord, where it is an existing right, my lord, I am assuming, my lord, that there was a right. I'm saying actually there's none because this is really, my lord, state. My lord, two decisions, my lord, I wish to cite. AIR 1966 Supreme Court. My lord, before that, I just wanted to, I was remembering, my lord, the case where this egalitarian had been referred to. My lord, CMC Velotta, 2020, Supreme Court cases
2020,
20, volume 8 Supreme Court cases 705.
704.
5, my lord, 5. Christian Medical College, my lord. Kindly take para 38. Kindly see, my lord, para 38 at page 773. My lord, it's Justice Mishra's judgment, my lord.
Yes.
In modern dental college, the Constitution bench considered the provisions of so-and-so in relation to right to freedom of private, unaided, minority, and non-minority. This court observed that the activity of education is neither trade nor profession, that is commercialization and cannot be permitted. It is open to impose reasonable restrictions in the interest of general public. The education cannot be allowed to be a purely economic activity. Now, my lord, is what I rely on. At every stage, my lord, it is a welfare activity aimed at achieving more egalitarian and prosperous society to bring about social transformation and upliftment of the nation. At every stage. And here, my lord, aided schools, my lord, are really, my lord, the, my lord, agencies, my lord, of the state. Now, my lord, on retrospectivity, my lord, All India Reporter 1966 Supreme Court 1758.
8.
175. My lord, kindly take paragraph 9. In this connection, it is relevant to distinguish between an existing right and a vested right. Where a statute operates in future, it cannot be said to be retrospective merely because within the sweep of its operation, all existing rights are included. As observed by Lord Justice Buckley in West and Gwine, retrospective operation is one matter and interference with existing rights is another. This is, my lord, very important. Then if an act provides that as at a past date, the law shall be taken to have been that which it was not, that act I understand to be retrospective. That is not this case. The question here is whether a certain provision as to the contents of leases, again contract, my lord, is addressed to the case of all leases or only of some, namely leases executed after the passing of the act. The question is as to the ambit and scope of the act and not as to the date as to from which the new law as enacted by the act is to be taken to have been the law. These observations were made in dealing with the question as to the retrospective construction of Section 3 of the Conveyancing and Law of Property Act. In substance, Section 3 provided that in all leases containing a covenant, condition, or agreement against assigning, underletting, or parting with possession or disposing of land or property lease without license or consent, such covenant, condition, or agreement shall, unless the lease contains an expressed provision to the contrary, be deemed to be subject to a proviso to the effect that no fine or sum of money in the nature of a fine shall be payable for or in respect of such license or consent. It was held that the provisions of the said section applied to all leases, whether executed before or after the commencement of the act, and accordingly, Lord Justice Buckley, this construction did not make the act retrospective in operation. It merely affected in future existing rights under all leases, whether executed before or after the act. The position in regard to operation of section 5(1) with which we are concerned appears to. And my lord, the other two cases, my lord, which are referred to are the same, my lord. And my lord, one other case on this, my lord, 1981, two Supreme Court cases, 293. My lord, kindly take, my lord, page 296. Paragraph, my lord, relevant paras are para 1 to 4. Having heard counsel for the parties at great length, we are satisfied that there is no violation of the fundamental right of petitioner enshrined in Article 19(1)(g) of the Constitution, nor is Article 14 attracted to the facts. There is therefore no good ground to entertain the petition. We would, however, like to add that on the materials placed before us, the government may consider desirability of adopting such measures as may soften the rigors of impugned orders, which though not arbitrary or excessive so as to violate Article 14, do merit some consideration in order to effectuate the policy. There are, however, two arguments urged before us which need special mention. In the first place, it was submitted that in the UP cases, the order imposing a levy on the khansari produced by the petitioners cannot have any retrospective operation so as to apply to stock of sugar manufactured prior to the date and would apply only to sugar produced. So far as this argument is concerned, we find no substance in the same because it is not a question of retrospectivity of the statute, but its actual working. Once the notification imposing the levy was made, it will obviously apply to stock of so-and-so produced either before or after the order. This principle has been clearly laid down by the Constitution bench of this court in the case of so-and-so, speaking for the court, etc. Then, my lord, that's the case, my lord, which I cited. This case followed the dictum of Lord Justice Buckley in the case of West and Gwine, my lord, which is referred in this circumstances, my lord, right at the bottom of page 29. Therefore, once for imposing levy, it naturally applied to stock of sugar, which was with the petitioners, irrespective of the fact that it was manufactured before or after the order. Then para 4, my lord, is. No, order দিতে চাই। কে বল? সবাই চন্দ্রচূড় চাটনি। Now, my lord, 2022, 12 Supreme Court cases. My lord, if it's really, my lord, in the nature of government employment, kindly have a look. 12 Supreme Court cases, page 1.
It is not a retrospective or prospective.
No, my lord, this is on vested right.
Yes, para
24, my lord. My lord, relevant paras are 24 to, my lord, 23 to 27. But my lord, 24 is what I'm really. My lord, the analysis after considering all the cases. First and foremost, transfer in an all India service is an incident of service. Whether and if so an employee should be posted are matters which are governed by the exigencies of service. An employee has no fundamental right, or for that matter, a vested right to claim a transfer or posting of their choice. And my lord, in the first case which I cited, my lord, which was, my lord, reported in, my lord, 2016
16 volume 5 SCC page 1.
Yes, my lord, abuse merely because there will be abuse, my lord, cannot be, my lord, a ground. My lord, that is reiterated again, my lord, reiterated, my lord, in fact, my lord, earlier, I mean, also held earlier, multiply.
It's a multiplying. If the same principles are there,
My lord, when people work hard, my lord, they like their.
So they should also read the another judgment of the Supreme Court in Rasmi metallic. Paragraph 5 or 6. If I correctly remember, so that they will not do this in future.
Yes, my lord, Justice Vikramjit Sen.
Yes. So they will not do it in future.
My lord, may I seek one indulgence? My lord, the cases they have cited, my lord, I won't, my lord, deal with them in arguments. May I put it in note? I'll just, my lord, very
Get that.
briefly indicate, my lord, one, my lord, set of cases, my lord, relate to, my lord, subordinate legislation. My lord, those tests, my lord, are wholly, my lord, irrelevant here. Second, my lord, are cases, my lord, which talk about vested right and, my lord, retrospective operation. My lord, here in my respectful submission, all those cases relating to retrospective operation are, my lord, covered by, my lord, two lines of cases I've cited. One is, my lord, they are really government employees, appointment subsumes it. There is no provision, my lord, barring, my lord, transfer in any event, my lord, in any of those contracts or, my lord, in any of the terms and conditions of service. Second view of the matter, my lord, is, my lord, that these are, my lord, it is not retrospective. My lord, it only interferes, if at all, with existing rights. If at all, I'm saying, my lord, it doesn't interfere at all. Then, my lord, comes, my lord, the question of vested right. My lord, here, my lord, there's no question of a vested right. And, my lord, if that is the case, my lord, then that, my lord, is, my lord, the end of the matter. I have to succeed, my lord, on the nature of service. My lord, it makes it simpler, my lord, a clearer cut rather. Then, my lord, there are cases, my lord, which relate to exercise of a power, which have been cited. My lord, those really don't, my lord, go into, my lord, a motive for a litigation. My lord, is not a ground for challenge. Because the debates will show, my lord, motives. My lord, each attacking the other. That's all they are concerned with. That's all. Because I've had a look, my lord, at there's no debate. My lord, it's not, my lord, Hiranmoy Basu, my lord, Jyotirmoy Basu, my lord, in, my lord, Parliament. My lord, or Pranab Mukherjee, my lord, who is, my lord, pointing out, my lord, provisions, my lord. It's not, my lord, in recent times, my lord, because I had the benefit of parliamentary debates for some time, my lord. The green book, my lord, reaching home, complimentary copies. But, my lord, that is, my lord, no longer there. But, my lord, anyway, my lord, that is what it is. So I'll, my lord, make a table, my lord, on, I've got it handwritten, but, my lord, my lord, I'll just do that if your lordships give me that indulgence. Otherwise, my lord, I have.
Do it.
Okay, oh, my lord, most important case, which I had forgotten, rightly reminded. Similar provisions, my lord, in the Madrasa Commission Act were challenged, my lord, in our High Court. Oh. Similar provisions. But the ground of challenge was, my lord, that these are minority institutions. You cannot have these provisions, identical provisions of the School Service Commission Act. 10C, my lord, all that. Giving, my lord, the power, my lord, to the government to transfer the exigencies. My lord, was struck down by the learned single judge and division bench, saying, my lord, that they violated 29 and 30. In the Supreme Court, my lord, those, my lord, decisions, my lord, was set aside. And the act, my lord, was held to be valid, including, my lord, the provision for transfer, specifically. My lord, that, my lord, is reported in 2020, 6 Supreme Court cases, 689. My lord, may I give you
20, volume 6.
Supreme Court cases, 689. My lord, may I indicate, my lord, the para numbers first?
Yes.
My lord, para 6, page 711.
Yes.
Para 9.3 and para 10, pages 716, 717. Then, my lord, para 17 and 18, page 722. My lord, the more paragraphs, I'm just telling your lordships, these paragraphs, discuss all cases up to TM pi foundation. Then my lord comes para 31, page 756, which discusses the ratio of TM pi. Then my lord para 34, page 768, to para 45, 788. My lord gives the situation, my lord, after my lord TM pi. My lord, so does my lord para 47 to my lord para 54, pages 789 to my lord 791. Now my lord, I'll place my lord para 54, para 58 and para 62. My lord, which is my lord relevant. Yeah, where is it? Yes, my lord, kindly have a look at the provision first. My lord, para 9.3. Yes. My lord, para 8, my lord, para 9.3. My lord, sections 12 to 18 of the Commission Act, my lord, are, my lord, set out. Kindly see 8. Notwithstanding anything contained in any other law for the time being in force, or in any contract, custom, or usage to the contrary, it shall be the duty of the Commission to select and recommend persons to be appointed to vacant posts of teachers in accordance with the provisions of this Act and the rules made thereunder. Now, my lord, kindly come to my lord, say para 13. I'm sorry, my lord, section 13 at page 717. Notwithstanding anything contained elsewhere
Having
in
a
this Act,
same
the terms
head
and
note. Having a same head note.
notwithstanding anything contained elsewhere in this Act, the terms and conditions of service of teachers in the employment of a madrasa immediately before the commencement of this Act shall not be varied to the disadvantage of such teachers insofar as such terms and conditions relate to appointment of such teachers to the post held by them immediately.
That is exactly section
Yes,
10.
yes. Now, my lord, kindly have a look at para, my lord, 10, my lord, of the judgment. The West Bengal Madras Service Commission Amendment Act 2010 made certain amendments in the Commission Act. Section 2 of Amendment Act is to the following effect. Now, my lord, kindly see. In section 8 of the West Bengal Madrasa Service Commission Act, after the words, or the non-teaching, the words, and also to recommend the transfer, including mutual transfer of teachers of non-teaching staff shall be inserted. Teachers or the non-teaching staff shall be inserted. So, my lord, now, my lord, kindly come to paragraph, my lord. First, kindly have a look at para 45 at page 789. Thus, going by the decision of 11 judges in this court, in TMA Pi Foundation, so long as the principles laid down therein as called out in para are satisfied, it is permissible if any regulations seek to ensure that standard of excellence of institutions while preserving the right of minorities to establish an administration. Then, my lord, kindly take para 46, placitum, my lord, D, one line above. A minority institution cannot, in the name of right under so and so, disregard merit or merit-based selection of students as regards the right to take disciplinary lays down even minority. A mechanism must be evolved and appropriate tribunal so and so. Then para 47, last 4 lines of page 789. But if ensuring of excellence in it is the underlying principle behind the regulation, and the mechanism is so designed to, mechanism of selection of this so designed to, matter may stand on completely different footing. Then, my lord, para 48, placitum C. However, when it comes to the second category, the governing criteria must be to see that the most conducive atmosphere is put in place where institution achieves excellence and imparts best possible. Then, my lord, regulations which will serve the interest of students, so also regulations which will serve interest are of paramount importance in good administration. Then, my lord, after all this, My lord, examination starts at para 54. My lord, all the sections, my lord, are, my lord, discussed. And my lord, lastly, kindly see. We therefore have no hesitation. Para 62, going by the test culled out and hold that provisions of Commission Act are not violative of rights of so and so. While allowing, we set aside the view taken by Saint Division Bench of the High Court, dismiss writ petition. We also hold sections 8, 10, 11, and 12 of the Commission Act to be valid and constitutional. And 8 is one of those provisions, my lord, which is para 9.3 and 10.
Yes.
I'm grateful.
Thank you.
Well, since I have to see the judgments, these are very long judgments. It will be futile if I continue. Kindly keep it
We
10:30.
we really 3 days, we really
That's
kept
true.
it for that.
True. Or Lordship may think
Now
of,
there, you have seen every day mentionings are
No,
there,
that I'm
they
seeing.
wanted urgency.
I'm seeing that. So Lordship may do one thing. Instead of blocking all other matters, Lordship usually takes up the matters from 10:30. Give me 30 minutes at 2 o'clock.
But you are there, but many are. Everybody will say, I have a right to give a
I
reply.
don't think
Maximum two.
Look at the gentleman.
Two.
Mr. Jana would be very much.
His leader will say, he not. His leader. His leader will
Oh,
say.
he says so. But he was nodding in a negative sense. That's why I just thought. So Monday too.
yes.
In the meantime, you give
My lord,
that
I'll do that.
write down small.
Yes, I'll do that.
But
My lord, on their cases, my lord, who has cited.
Yes. What advance copy? Nothing. He has already argued. You have given it. Yes, give it.
Judge.
My learned friends can give it to me, I'll include it in the list.
Compilation. Better হবে।
No, compilation, no.
আলাদা করে।
My lord, I am preparing compilation at home. My lord, I'm not going to prepare a compilation of their judgments.
Of
Just the
course.
judgments given to me, I'll deal with them.
Yes.
I was
You
just-
give him a copy of the judgments.
Okay, দিয়েছো ভাই।
Just give it. Please write down the name. Monday at 2 p.m. Matter to continue. এটা একটু সাবধানে বেঁধে রেখে দাও। Whose book is this? একটা বার আনাও বেঞ্চ থেকে।
স্ক্যান করে নি।
ও স্ক্যান করে তোমাকে পাঠিয়ে দেবো।
আমি 10 কপি করেছি কালকে।
ব্যাস।
যদি কারোর লাগে আমি দিয়ে দিচ্ছি। আমার
একদম।
ফাইলে আছে।
Correct.
তুমি ওটা স্ক্যান করে
হ্যাঁ।
তারপর যা লাগে আমি জেরক্স করে দেবো। ওই নোটিফিকেশনে দুটো কপি আমি কালকে আমার ফাইলে ঢুকছি। কনস্টিটিউশন নিয়েছে ওই বইটা নেবো। বই কি ফেরত নেবো আজকে না সোমবার নেবো? সবুজ বইটা দেবে? নিয়ে নেওয়াই ভালো। দাদা সবুজ বইটা দেবে? রাইট ওয়েট। আচ্ছা সবুজ রঙের একটা পেয়ার আছে। সবুজ একটা পেয়ার আছে। না, না, হতে দেবে। এই কারণে time নিয়ে নিচ্ছে। Time নিয়ে নিচ্ছে, এই কারণে দিচ্ছে।
আচ্ছা আপনাদের report কে আছে
এই, কাকিদের সঙ্গে।
বাইরে
এখানে কথা বলো। বলছি এইটা আমার গো, এই যে আবার সোমবার দেবো। কারণ ওই তোমাদের মধ্যে, হ্যাঁ, ওই তো দুটো কপি আছে, দেখি চলো। এই, শিব, এই দাদা, শিবম, এদিকে আসো। হ্যাঁ,
Item number 2, my lord. In this case, I am appearing on behalf of the respondents.
Why it has come up? City Court?
This is a matter of.
Yes, released. Next.
3, I am appearing for the appellate order of city.
Yes, release. Next. Yes, it appear. Hearing. Anybody is here?
Yes.
The matter has been assigned to your lordship.
Yes, what is this? Where is the hearing?
My lord, disturb.
পেপার বুকটা দাও যখনই অ্যাপিল শুনানি হয় ফার্স্ট পেপার বুক যখন রেকর্ড চাইবো তখন রেকর্ড দেবে
জজের রাখুন।
The defendant is the appellant.
You are for the appellant. Just 1 minute. Was it heard by the other bench?
It was heard by earlier occasion by your lordship sitting in my lord.
Not by me. Definitely not. I never use these colored. I never use. What?
Might be favorable.
Exchange. My
Exchange.
brother also does not use that color. আপনি করেন color?
না।
কখনো color use করি না। Never use.
By your lordship, it was made CAV subsequently pursuant to the application filed by them. Mention and matter.
Just 1 minute. Give us 5 minutes time.
I'll take that for 652.
Just 5 minutes time.
10 minutes.
Yes, who is for the defendant? Appellant,
I am for the defendant appellate.
yes, what is your stand?
The document which is termed as an agreement for sale.
Where is that agreement for
Yes,
sale?
my lord. If your lordship may kindly consider the original copy, though it is annexed with the paper book that my lord will find at page volume 2,
Part two, not
part 2,
volume
volume 2, my
two.
lord, part 2,
Yeah.
page 1.
Grohita is Ramesh Biswas, Sajay Biswas.
Yes, my lord.
And Binapani Rai is a data.
Data.
Yes.
Gone through the document itself. Now, if your lordship may kindly consider
First point is signature on every page at the top.
at the top and where, my lord, kindly consider page 4. My lord, I've gone through it.
Yes.
Ishadi at the bottom.
What?
Ishadi, my lord, at the bottom, page 4, at the bottom, my lord will find the column Ishadi.
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 Yes. That has been admitted by you, your handwriting.
This is not my handwriting.
It is admitted.
This is not my handwriting.
The trial court has held that it has been admitted.
That is why, my lord, I'll draw your lordship's attention. So, for
What
the
more?
deposition and other things, whether it is admitted or not.
14 তারিখে 20,000 বুঝিয়ে পাইলাম।
Yes,
What
that is
for?
my lord. অদ্য পূর্বে 30,000 অদ্য 20 মোট 50,000 টাকা বুঝিয়ে পারছে বিনাপানি রায় at the bottom my lord will find this is the signature. This is the signature admitting that she got rupees 50,000. Now my lord, left hand side মুসাবিদা কারক
Yes.
নারায়ণ চন্দ্র ঘোষ.
Now you have got a better relation, your husband.
No, there is no relation. My allegation is that everything is done by Narayan Chandra Ghosh. Criminal case proceedings were initiated. Not only that, he have divorced. Now, at present, divorce. Now, can you consider? And furthermore, my lord, if your lordship may kindly consider, why we say that this is a loan in. If your lordship may kindly consider page 3
Of
the same document.
yes.
Your lordship will find this is the handwritten portion, the middle of the
Yes.
that was filled up by the plaintiff.
Have you proved that particular signature to be filled up by
It
the
is admitted admitted in evidence
what?
that plaintiff has filled up this portion. It is his handwriting. Now, my lord, can you consider the plaint once? What is the sum and substance of the plaint? I need not to go only for the purpose of whether I'm illiterate or not.
You are well versed with the Bengali language. You are a most. You
No, my
are
lord,
found to be an
I am
educated
able
lady.
to. I can put my signature only. That is my evidence.
You were found to be an educated lady. What more?
The court found, my lord, on basis of which, my lord, that record to be considered. Findings based must be some evidence. What are the evidence before the court? Now, if your lordship may kindly consider If that be so, then my lord, I'll not trust my son-in-law, though not mine. It's my sister daughter who used to reside with me. Ratna Rai, who is now present appellant, she died. Her husband used to look after. Her husband used to look after the entire affairs of the family.
Narayan Chandra.
Narayan Chandra. Now, my lord, can you consider the plaint ones? May I read out? If you call it
Yes. Kindly visualize, there has been an amendment which is carried out in the Specific Relief Act.
Yes, if it is found, if it
Now,
is found.
now, I am again saying, now it is no longer a discretion of the court to grant a degree for specific performance. Now it has become a mandatory.
If
The
that is the agreement.
moment the agreement is proved,
Yes.
the moment the readiness and willingness, I find that there is no discussion on a readiness and willingness part. It is
But
the
there is
duty of
evidence
the court to grant.
But the agreement, whether it is an agreement,
Now you say that you were in dire need of money. You approached several persons, initially took the money. He was pressing hard to get back. You paid back the money, taking loan from other. He was also putting pressure on you to pay back the money. You took it from him
yes.
and then paid that money. There was another property. This property was there, a subject matter of suit where you have agreed to purchase the 1/3 or a 1/4 share.
1/3 share.
And you need that 80,000 rupees to be paid to him.
40,000 gave by my husband and 40,000 by loan. I obtained loan. That is to Narayan. But Narayan did not purchase that property. Criminal proceedings were initiated. Now, my lord, can you consider how the evidence of PW?
Page
Page, my lord. Page 50.
50.
50.
Yes.
I am drawing lordship on page 51.
Yes.
The defendant, an agreement dated 19/1/1994 agreed to sell the suit property to us at price of rupees 1,27,000. On the date of agreement, we paid 30,000 to the defendant as earnest money. Thereafter, on 19/3/1994, we paid rupees 20,000. Defendant further advance. According to the agreement, the sale was to be completed within a year for payment of balance consideration money by us. The written agreement has been filed. The agreement between us, it was drafted by Madhav Chandra Ghosh. Madhav Chandra Ghosh has typed it, and also in my presence. The defendant put her signature on all the pages of the agreement in my presence at her residence. In my presence at her residence, my lord, can you consider? Defendant's daughter Ratna Ghosh and her husband Narayan Chandra Ghosh also signed upon the agreement in my presence as witness. The endorsement in the agreement is the handwriting of the defendant's daughter, Srimati Ratna Ghosh. There is another endorsement by Srimati Ratna Ghosh made on the agreement in my presence. The endorsement bears the signature of the defendant of the endorsement with the signature marked Exhibit 1B. After that, my lord, kindly turn to page 54. So these are the sum and substance in the initial. Now, my lord, kindly. Not a fact that defendant had not received rupees 50,000 as once. In total, not a fact that I got the agreement for sale executed by the defendant by
These
fraudulent
are all
means.
suggestions.
Yes, after,
These are all
not a fact after that, my lord, the defendant had herself. That is why I have drawn lordship attention. Not a fact that the defendant had not received rupees such and such in advance in total. Not a fact that I got the agreement executed by the defendant. The fraudulent means with help of defendant's son in-law Narayan Chandra. Not a fact that I met defendant in her house after the notice that the defendant had herself gone through the agreement. Her daughter had also read it over and explained to the defendant. Defendant's document Ratna Ghosh is present in courtroom, not a fact that the defendant is an illiterate lady. So this is, if that be so, my lord, I'll come later on the cross-examination what he has stated. My lord, kindly turn to page 55, the cross-examination. I have a sweetmeat shop in the market. There are about 300 business establishments in the market with a businessman to run a cooperative. I cannot say whether the cooperative gives any loan to anybody. I am not a cashier of the cooperative. All my brothers have separate shops in the market. The name of Madhav Chandra Ghosh appears in the agreement, but agreement does not bear his signature. Pause here for a moment and kindly consider the cheap ones. It was drafted, my lord. Allow me to read out for the sake of the repetition, my
It
lord.
was drafted by
Madhav Chandra Ghosh, Madhav Chandra has typed it
He
also in
typed
my
it in my
presence
presence
and
and
had put signature. Devener put signature upon all the pages
that is the
agreement in my
defendant
presence.
has put a signature. But here he says that the Madhav Chandra Ghosh did not sign on the agreement. He
Yes.
prepared it, typed it.
Now, my lord, kindly consider the Madhav Chandra Ghosh, who is the এটা কত বিলটা বল না page 1. The name of Madhav Chandra Ghosh appears in the agreement only as typist, but Srimati Ratna Ghosh and Narayan Chandra Ghosh signed in the agreement as witness. But from their my lord, it is a Mushavida Karok. In the document from there, my lord, your lordship will find this Madhav, Narayan Chandra Ghosh and Ratna Ghosh name is appearing as a Mushavida Karok. Put his signature. I have never any enmity with Ratna Ghosh and Narayan Chandra Ghosh. Ratna Ghosh with her husband used to
From
reside.
where you are reading?
Page 56, my lord.
Yes.
I had never signed as the agreement as witness, my lord. Got it? At the top, my lord will find.
Yes.
But from the document itself, my lord, their name is appearing under the Mushavida Karok. There is not the witness. Page 4, my lord, will lordship find document as Mushavida Karok. This Ratna Ghosh, even if assuming, my lord, they have signed after. I had never in enmity with Ratna Ghosh and Narayan Chandra Ghosh. Srimati Ratna Ghosh with her
But
husband.
simply a neighbor. Simply a neighbor.
Now, my lord, at the bottom, my lord, I had never enmity with Ratna Ghosh and Narayan Chandra. Ratna Ghosh with her husband used to
You
reside.
say that the Madhav Ghosh signed as a witness. PW1 says the Madhav Ghosh signed as a witness.
As witness. As witness. But the Madhav Chandra, that is why at the later portion, Srimati Ratna Ghosh and her husband now live separately. Madhav Chandra Ghosh signed upon the agreement as witness.
I have read it faster than you, sir.
Sorry, my lord.
And page 57 says that I will not call the Madhav Ghosh as witness.
And the relationship between the present appellant and her husband, it was also admitted that they are residing separately by the plaintiff himself. Now, my lord, kindly consider not the fact that the handwriting portion of the body of the agreement were not there when the agreement was signed by the defendant. Because our case was that there's a blank paper which was converted.
That is, I understand. Your case was that at the time of taking the loan, certain demi papers, blank papers, you were made to make, you were, I would say, pressurized to put a signature thereupon. Since you are in dire need of the money, you put the signature, believing that he will not do anything. Now he has converted those papers into an agreement. This is your case.
Yes. Next, my lord, kindly, on the date of agreement, I paid rupees 30,000. Now, my lord, kindly consider when the পূর্বে 30 অদ্য 20 মোট 50,000 টাকা বুঝিয়ে পাইলাম মানে previous what is the date for initial agreement that is in the month of January.
He says that on the date of an agreement I paid 30,000 rupees and later on paid 20,000 rupees, in total 50,000 rupees
Yes,
out of 1,27,000.
but this agreement was entered into between the parties. My lord, if your lordship kindly consider this agreement was entered into between the parties
1994
1994. This is
January.
1994 is the initial agreement. And my lord, kindly consider the date which was mentioned in the document itself, page 4, volume 2. Part 2, volume 2. My lord, I beg to catch it again. 19th March 1994.
Yes. Where is the date?
Part 2, my lord, page 4.
Sir, this document, please consider, this document was executed on 19/1/1994. there was a payment of rupees 20,000 or 30,000. I think the 30,000 was there. And thereafter, on
Then my lord, at
subsequent
the
date,
top.
another amount was paid, which was paid definitely after 2-3 months.
Then my lord,
And
kindly
in
at the
total,
top,
you
my lord
said
will find.
50,000 you have received in total.
Yes, my lord, kindly turn to page at the top. Date when the signature was put in 1994.
Correct. And the signature that moat means total.
Yes.
50,000 rupees taka bhujia pailam is 1903 to 1994 means more 20,000 when it was paid or 30,000 was paid, then he got it.
Therefore, on the date of execution, this had signature was not there.
It was put
Subsequently, my lord.
subsequently to this, no doubt.
So 1994, this document, this signature of Binapani Rai was not there. On the date of execution of the agreement, my lord, kindly consider, because at the top, my lord will find the initial signature is 1994.
Mr. Roy, have you ever come across with these kind of an agreements? If an agreement for sale is executed, and then there are many cases where the parties are paying in a due period of time or in a course of time. So on the back of it or on the face of it, they put their signatures, though the agreement was executed earlier, that I have received today sum of rupees this much. I received today sum of rupees this much. These are all on the original agreement they put it.
Yes, my lord. If your lordship, that's why, my lord, I am drawing lordship attention.
So
but the
what
bottom
is
portion
the
signature? The bottom portion signature was
was later on
Yes.
when she was paid the entire 50,000 rupees. She says, initially I received 20 or 30. Later on, I received the rest. Total amount 50,000 I received as on 1903 to 1994.
yes. So therefore,
Put the signature on the agreement.
yes. Therefore, my lord,
Now,
on
sometimes
19th.
it is on the reverse side of the agreement, sometimes at the bottom.
So therefore, my lord, on 19th, whether this signature was there or not,
What signature?
at the bottom signature, page 4, my lord, at the bottom. That's why I draw lordship. It
Yes.
was not there.
Which not there means, how can you say it was not there?
Because, my lord, why the initial agreement was executed on 19th January
That
1919.
was at the top when you put your signature. I do
That
not
is the
know.
date of agreement.
When a document can be said to be executed, when both the parties put their signature thereupon, that is the date of the execution.
Yes, that is the 19th.
So 19th January, everybody put their signature. That was the date of an agreement.
Yes.
Now it appears that a very small amount was paid, though he is supposed to pay the 50,000 rupees, which he paid after 2 months, the rest amount, totaling 50,000. And then, in order to secure his position, may ask the plaintiff, may ask the owner or a vendor, please write that you have received 50,000 as on this date. So say 50,000 as on this.
This signature is regarding the acknowledgement of 50,000.
But that is admitted by you that these are my signatures and these are my writings. Why you write it?
That is
You have admitted that you have written.
this is
when-
my signature.
Now, second thing is when the agreement was already there, and when you put all these words here, please, there are two presumption, strong presumption would have to be considered. You have put those signatures here. You knew it that the signature is there. There are two things. One is that this document was absolutely blank,
Document blank.
containing. Please, where is your evidence? I have to see.
Yes, my lord, evidence.
Please, it was blank, containing only your signature at the top. And then at the bottom, you have written it. And later on, they filled up the blank portions, which does not appear to be so. Which does not appear to be so. Your initial case was that you put the signature on all the blank papers,
Blank papers.
and which has now been converted into an agreement.
Yes.
You did not give any explanation to these writings.
Because in the stamp paper, there is no signature.
Puri,
That is why in the stamp paper, which
what
is
are you
there,
saying? They original thou? Degi, hey, লোয়ার কোর্ট রেকর্ডের এক্সিবিটস এ বাক্স আছে না ওটা আছে? কোনো বাক্স আছে? নেই, দাও এমনি।
At the right hand corner.
Let us see from the original. This is a photocopy. One
The right
cannot
hand
believe-
corner, it will there, my lord. Page 1, my lord, your lordship will find.
এই দেখো তো একটা ফিরিস্তি হবে ডকুমেন্টস এ,
আছে।
এখানে আছে। দাঁড়াও, পেয়েছি। নো নো, একটা দেখো তো আরো আছে
আছে, আছে।
দেখি।
My lord, may I find it? There is a signature at the side, my lord, will lordship will find.
না থাকে, একটু পরে থাকে, একটু প্লিডিং অর্ডারের পর একটু থাকে। বায়নাপত্র এখানে আছে, কি বলছে এখানে, এটা তো অ্যানেকশন। এই দেখো তো অরিজিনাল ডকুমেন্টস
থাকবে
কোথায়
মনে
আছে?
হয়, ওটা, my lord, may I find it out for your lordship?
Now I got it.
At the right hand,
I got it. আছে তো, রয়েছে তো, রয়েছে। বলুন।
there's photocopy, my lord, I do not find. At the side, my lord, might be there. It is-
No, at the bottom,
It's
same way. Mr. Roy,
not there.
you have invited us to go into the original.
Yes.
We are thankful to you. Look at in what way this document is exhibited. You did not raise any objection to the documents while marking as an exhibit. Did not raise any objection. It was your duty at the first moment the document is tendered that you raise an objection. You did not raise any objection. Practically marked without objection. We have seen the Firisti.
Yes,
It always contains.
at the top.
So, এখানে কিন্তু লেখে না।
Probably it is.
না, PW1 এর evidence আছে, page.
It is marked with objection. Page 51, exhibit 1, marked with objection.
Show you cheat.
The paper book, page 51. My lord, referring at the bottom. 1, 2, 3, 4, 5, 6 line from the bottom. Exhibit 1, marked with objection.
But in the seal it is not.
At the top right hand, my lord, there is no such endorsement by the presiding officer.
Yes.
Now, if your lordship may kindly consider, the documents for the sixth argument, my lord, I am drawing lordship attention. What was the document? This is mentioned in there. My lord has gone through the entire document from where your lordship find that the blank portion has been put somebody else without any signature regarding the acknowledgement of by the parties. Because, my lord, if anything is done in a typewritten, my lord, it is a normal practice that the parties to the document should put counter signatures regarding the portion which is made by the handwriting.
That is an initial, not signature.
Initial, any sort of,
Yes.
but my lord, your lordship will find from the document itself. Page 3.
Yes.
After that, my lord, your lordship will find what is the recitals made, what is the agreement. আপনার নিকট উক্ত মূল্যের নগদ 30,000 টাকা বায়না গ্রহণ করিয়া, so at the initial they have to deposit 30,000 rupees. ও অঙ্গীকার করিতেছে যে অদ্য হইতে 1 মাস বছরের মধ্যে উক্ত বায়নার বকরি 2 মাসের 20,000 টাকা গ্রহণ করিয়া বকরি টাকা বাদবাকি সময়ের মধ্যে আপনার উক্ত অদ্য তারিখে 30,000 ও আগামী 2 মাসের মধ্যে 20,000 টাকা মোট 50,000 টাকা বাদে বকরি 70,000 টাকা পরিশোধ দিলে। Now my lord, pause here for a moment and kindly turn to next page. Just opposite, what is there, it is just opposite that been written in the receipt portion. অদ্য তারিখে 20,000 টাকা, পূর্বে 30,000 টাকা।
Yes.
Now, my lord, I am drawing lordship attention so far the
এটা ঠিক।
evidence of the DW. So what is there, my lord, is contrary to what is the ultimate receipt. And my lord, the witness, I am the defendant in this suit, my lord, page 60 of the paper book. My lord, once I want to read out the enter the chief and the cross. I can just sign upon a document. I am otherwise illiterate. I have no children. Ratna is the daughter of my sister. I brought her as my daughter. I had some properties at Calcutta. It was a residential house where I used to reside in. We are the owner of 3/4 share it. I had paid money to Narayan Chandra Ghosh to deposit it in share. But Narayan Chandra Ghosh purchased the said 1/4 share in the name of somebody else. I paid rupees 80,000 to Narayan Ghosh for that purpose. I collected the money for sale of my ornaments, a part of it collected from my husband brother. I took 40,000 my husband brother. I had repaid the said amount to me, taking loan from Netai Dash of our locality. I repaid the loan, taking another loan interest from another person of our locality. I took the loan from Ramesh Chandra Bishwas. Is a loan party in the suit. Is a loan party in the suit.
LONE. LONE. Not LOANE.
Loan party in the suit. My son-in-law Narayan procured the loan for me. I had signed upon some blank papers in connection with the loan. Narayan Chandra Ghosh had brought those papers before me. I cannot say as to why I signed upon those papers. I had signed upon those papers just at the instance of my son-in-law Narayan. Plenty was also with Narayan when I signed upon the papers. Plenty has given to Narayan rupees 20,000 on one occasion and 20,000 in another occasion. Out of those, 40,000 was paid to direct to Nitai Dash. My relationship with my son-in-law is not good. At present, Narayan had misappropriated a lot of money, and for such misappropriation, my relation with him has become bad. I filed another case against Narayan for his misappropriation of money. I received a letter from plaintiff. I handed over to Narayan. I received another letter from plaintiff. My daughter read over and explained the letter to me. I came to know from that the plaintiff has filed the present suit against me. So, my lord, kindly consider here, he categorically said, my lord, how this was cross-examined, my lord, that I cannot read. It was read over and explained by my daughter. After that, I came to know that documents has been executed as agreement for sale. Having received the second letter, I called the plaintiff and told him that I'll return his money after the sale of my house. I had offered the repayment, but he refused to accept. Ramesh told that he would not take any further step that everything would be settled on payment of money. But he refused to accept payment and demanded the transfer of the suit property in his name. I had taken time from the plaintiff for an year repayment of money. The plaintiff refused to accept the payment from me repeatedly. The plaintiff had returned to me. The plaintiff have returned to me all my documents of title, which are handed over to him. Not a fact I agreed to sell the suit property. The plaintiff received money of such. Not a fact I received 50,000 honest money for the sale of the suit property. Now, my lord, in the cross-examination portion, last portion, I had filed this written statement of the suit. These are all my signatures. The signature have been prepared under my instruction. I cannot say the dates of misappropriation. I have no documents to show that I filed this case against Narayan. The case ended long ago. Narayan was convicted and impersonate in the case. My lord, pause here for a moment. What I have no other document, but a complaint was lodged, and that will she will find was just disbelieved by the learned trial court. That is at page.
No, the case was he was convicted and imprisoned. What was the case and in what case?
Yes,
he
that
was
my lord is by page 28, volume 2.
What is that?
That is the information.
it-
What is the case and 406 and 420 of the Indian Penal Code.
Was it marked exhibit?
Yes, my lord.
That was to treat it as an FIR.
Yes, and the case was started, my lord, your lordship fine. Case number C471 dated 35/1994 under section 406, 420 of Indian Penal Code. IC Barwa PS to treat the petition of a complaint as a FIR.
What
and
happened? It is he has been found.
convicted, subsequently convicted.
Evidence বলেছে।
I had not found it. I have not gone through the agreement of the sale filed by the plaintiff in the suit. My sister knows that Narayan took loan from the plaintiff for me. The negotiation for the loan was held in my residence about 3-4 years back. Narayan, my sister, and myself were present during such negotiation. I cannot remember whether the plaintiff was present or not. This is my signature. Shall not call any witness to prove the plaintiff is a money lender. My relation with Narayan was good when I received the second letter from the plaintiff. I have no document to show that we have a residential house at Calcutta or there was a suit in connection with the property. My daughter Ratna may be examined as a witness. Ratna's relationship with the husband is neither good nor bad. This is my signature. I have all faith of my daughter Ratna. I had signed upon the blank papers. The witness replied after signature exhibit 1B was shown to her. I know nothing about the agreement for sale. Not a fact. I agreed to sell the suit property to plaintiff such and such. Now, my lord, page 67, last paragraph. I had signed one blank stamp paper and upon 4 or 5 blank plain paper. I cannot say the date of those signature. I signed upon those blank papers in my own home. Plaintiff and Narayan were present. I cannot remember who else were present at the time of my signature. My relationship with Narayan is not good at present. Hence, I will not call him for witness. So far, there is no suggestion on the part of the whether you are literate or illiterate, whether you yourself gone through the documents or not. Nothing has been stated there. Now, my lord, kindly consider the cross-examination. The last portion, my lord, not a fact I had negotiated with page 68. My lord, I'm continuing that cross-examination. The last.
Yes.
I had not lodged a complaint local for plaintiffs obtaining my signature on blank papers. Not a fact, plaintiff never met me second time. Not a fact, there was never any talk of loan between myself and the plaintiff or between plaintiff and Narayan. It is not a document for. It is not a fact that document for sale is not a document for security of loan and never addressed in letter to plaintiff express my intention. So, my lord, there is not a single question put forward to the witness whether you are literate or illiterate. When the specific argument or the deposition is made that I am an illiterate, I can only put my signature. There is no cross-examination on that score.
Yes.
Now, my lord, the Rotna's evidence. Rotna's evidence, my lord, page 72.
Yes.
Only thing, my lord, initial portion is the facts narrated regarding the husband who took the money but did not execute the document. I'm not on that also, my lord. Next page, page 74. The amount of loan taken from the plaintiff was 40,000. My husband had arranged for the loan. I cannot say any detail about the condition of that loan, but I know that the defendant had put her signature upon some blank papers and the defendant had to hand it over all her documents of title to the lender. The amount of loan had not been paid in my presence, but I was present when the defendant put her signature upon a blank paper and upon some other blank papers. The signature thus obtained had been obtained for the purpose of creating some securities against the loan. All these writings in my handwriting. This is my signature, the date not in my handwriting. The papers were blank. I made those writings, it and sign it upon it. Because the two dates are there, my lord, at the top, my lord will find in English, and the bottom, my lord will find in Bengali. The defendant requests to money to pay off the loan taken from Nitai Das. She asks my husband to arrange for the money. My husband contacted with the present plaintiff and convinced the defendant that the defendant required to sign upon some blank papers to get loan from the plaintiff. Hence, the defendant signed upon some blank papers, including the stamp papers. On the first occasion, rupees 20,000 was paid to the defendant. Then I made the endorsement in blank papers. Thereafter, plaintiff sent an agreement for sale. But the defendant refused to sign upon it. Thereafter, the plaintiff had paid rupees 20,000 to the defendant, and at the instance of my husband, I made the endorsement 1A. That is the subsequent portion. Thereafter, the plaintiff sent an agreement for sale, but the defendant refused to sign it. Thereafter, the plaintiff paid rupees 20,000 to the defendant, and at the instance of my husband, I made an endorsement, that is exhibit 1B. In the blank papers, although the amount acknowledged by such endorsement was not true. There is a agreement for sale which was bought by my husband for defendant's signature, marked X for identification, because only the signature of Ghosh was there, Narayan Chandra Ghosh was there, so it is only for marked identification. Though I have annexed the same, my lord, it is there. That is at page 25.
Yes, then.
I have received this document from my husband. The document bears the signature of my husband. I know my husband's signature. My relation with my husband at present is very bad. It was not deposited in the name of my defendant's husband in the court of the money which was paid to him for deposit in the name of the defendant's husband. I raised protest against such conduct of my husband. As a result, I had been subject to torture and my husband because of such facts. My relation with my husband lost diaries in Muchiwara PS, Calcutta, and it was Barshat PS. Now, my lord, the cross-examination. Page 79. The negotiation between the plaintiff and my husband was not held in my presence. All negotiations for loan took place between my husband and the plaintiff. We know everything through my husband. We do not have any document regarding the sale of defendant's ornament loan from the business of the defendant's husband. Knows this fact well. I cannot say the date when the loan was taken from Niranjan Rai, who was the brother of the husband of the original Binapani Rai, or when the said loan. I cannot say also the exact date when the loan was taken from Nitai Das or when the said loan was repaid to him. We do not have any document to prove the loan taken from Nitai Das. Nitai Das also adduced as a witness in this proceedings, my lord. There was never any agreement for sale for the suit property. The defendant put a signature in blank papers in the year 1994. I cannot say the exact date. I know about those signatures since 1994. We were lodged any complaint GD entry in the PS in connection with the defendant's signature upon the blank papers or my endorsement upon them. I don't know about the loan given by plaintiff to anybody in our locality other than to us. The plaintiff had sent a notice prior to the suit. I read over and explained the contents of the notice to the defendant. and the defendant had called the plaintiff in her house in connection with that notice. I cannot say the date when the plaintiff came to her house on that call. On the day when the plaintiff came to her house on call, myself, my real mother, and my defendant's husband and the defendant's husbands were present in the house. On that day, plaintiff had returned the defendant's deed of title over the suit property, and the plaintiff further assured that he will destroy the documents containing the defendant's signature in his custody after repayment of the loan. I cannot say the date when the defendant's deed of title, over the suit property was handed over to the plaintiff. My relationship with Narayan is, well, it should wrongly, my lord, good. I cannot say the exact date when the defendant had put his signature upon the blank papers. Myself and my defendant were only present when the defendant put her signature upon the blank papers. I put my signature upon the document 3 months thereafter, because the later portion, my lord, will find that is in the month of March. Earlier, it is in the month of January. I passed secondary examination and read and write in English and Bengali. Not a fact the defendant had consciously signed upon the exhibit one knowing its contents, which are there in the documents prior to her signature. Not a fact that the defendant exhibit agreed to sell the property to plaintiff at a price of such and such. Not a fact the plaintiff has paid the defendant a sum of 50,000 total earnest money. Any transaction loan between the plaintiff and the defendant. Pause there for a moment. Now, question was put forward by the to the witness. Whether, because it is the case of the plaintiff, that at the time of execution of that agreement, not only that the plaintiff defendant herself, and it was read about and explained by Ratna. Therefore, no question in cross-examination, my lord, will not find that any question is put forward that the agreement which was read over, whether it was read over or explained to the defendant before agreement or not. But it is a specific case of the plaintiff that the defendant, after going through the documents, understood the contents and put her signature. And the judgment which is delivered by your lordship, that read over and explained, must be some indication. If it is read over and explained, then my lord, some indication must be there in the document itself. Even if assuming that the read over and explained by Ratna, then there is no question put forward in the cross that it was read over. And because it is a specific case that the later subsequent letter was read over and explained by Ratna, from where she first time came to know that this was created for the purpose of as an agreement for sale. Now, if your lordship may kindly consider the evidence of Netai, that here lordship find page 69. This is
The daily laborer
has
said, I paid money and I got money. I have no claim against it.
yes. So, my lord, I want to establish the sequence which I intended to establish along with the witnesses. Now, my lord, once for the sake of repetition, my lord, I am drawing your lordship attention to page 1 of the agreement.
Which one?
Page 1, volume 2, my lord, the original agreement, my lord, have considered.
Yes.
At the bottom, my lord have gone through the original. There is an thumb impression of the page 4, my lord, at the bottom, my lord will find there is a impression of the thumb. I do not know, my lord, whether in the original it is there or not.
Yes.
There is a thumb impression at the bottom, my lord will find.
Where?
The document, my lord, I have gone through it. I do not know where.
Which document?
Page 4, my lord, the agreement. volume.
Yes, some impression is there.
Yes, but nothing, neither in any evidence, the thumb impression was not been called for. It is whose thumb impression? Because this is not a case of the plaintiff, that someone else also there who put as
But it is all along a case that she has said, this Ratna who came and said that I have written this.
I have written the regarding the only the receipt portion that was explained.
But there is a signature. Now the things are that if there was a signature on a blank paper, the signature of the defendant is also appearing in a stamp paper.
Yes, what that is why it is not on the bottom, but on the side, because it is a normal case, but not in a loan. At the time of obtaining loan, my lord, they used to take a signature on the blank stamp paper. And this is
Stamp
why,
paper you have not said, blank stamp paper.
yes, I have said, my lord, in my evidence, my lord.
You
once
said
my-
demi paper, blank demi paper.
No, my lord, stamp paper, one stamp paper and 4 demi papers. I have said, my lord. My lord, may I draw your lordship attention to that portion once? একটা স্ট্যাম্প পেপার ইয়েতে বলেছিলাম সাইন আপন না না সাইন আপন না এই ব্ল্যাঙ্ক পেপারস ব্ল্যাঙ্ক পেপারস না একটা স্ট্যাম্প পেপার কথা আমি বলেছি একটা চারটে ডেমি পেপার একটা স্ট্যাম্প পেপার Oh, yes. My lord, can you turn to page 67? At the bottom, my lord, you'll find I had signed signed upon one blank stamp paper and upon 4 or 5 blank plain papers.
Where 67
At the bottom, my lord, you'll find
at the bottom, 60. Oh, sorry. Yes.
Therefore, my lord, it is not my case that something. It was my case that you obtain the signature for the purpose of collateral security in the stamp paper also. Subsequently, it was converted. That is why, if my lord, I can prove that yes, I am an illiterate, or even I can put my signature without having any knowledge about the regarding this transaction. Then, my lord, I am entitled to get whether it is my duty to prove or onus upon me, or the person who gets the benefit out of that agreement is supposed to prove their case. Because my illiterate portion has not been cross-examined, no question put forward, neither to me nor my daughter. Though it is my sister's daughter, I used to look after her as a daughter Ratna.
Yes.
So, on the basis of this evidence, my lord, the lordship may kindly consider. Now I draw lordship attention to the judgment.
You have already read a judgment. Now you want, what do you want to argue? Tell us.
Yes. এত তাড়াতাড়ি গেলে কি হবে? যশোর দূর। My lord, the issue number 6, my lord, is that is at page 92.
Yes.
Four and 6 is the main issue for the purpose of my lord, subject to correction, my lord. whether this is an agreement for sale or it was a deed dated 19/1/94 consensually executed by the defendant. So this was the issue.
What is this? Exhibit 5? It is your
It's a
reply
letter.
to the notice.
Notice.
What you have said in your reply. Have you read that reply?
No, but there are two notices. That's why, my lord. There are two notices are there.
Exhibit 5.
Exhibit 5 and Exhibit 6, my lord,
I'm
page 9.
talking about 5.
Yes. These are the, my lord, kindly pause there for a moment and kindly consider my evidence.
Exhibit 5. Exhibit 5 এখানে ফাইল করে দিয়েছে।
I had also signed upon the notice and the copy of the notice that is at page 52. This is the postal receipt, Exhibit 2, Exhibit 3, the card bearing signature, defendant Exhibit 4. The defendant received the notice and replied to it. This reply I received from the defendant through post. This is an envelope in which the notice is sent. Again offered the balance consideration money, such and such, on 31st
What you have to say about exhibit 5?
Exhibit 5, the documents came, I hand over to my son-in-law.
What?
Yes,
You have not said anything
yes,
about it.
yes, my lord, kindly consider. I
Please
have
come
said.
to the evidence of
Yes,
plaintiff
yes, my
regarding
lord.
exhibit 5.
Yes, my lord. That portion, my lord, I am drawing your lordship attention.
Where is exhibit 3, 4, 5? Yes.
Yes. Page 63.
You did not raise any objection to this letter, exhibit 5. You did not raise any objection.
That objection
Then,
probably is not.
then
But if your lordship,
where is the cross-examination on exhibit 5?
only this portion, my lord, can turn to page 63. In a,
Show us.
no, only the
No,
portion.
no, to the plaintiff.
Yes.
Where is that? 63. 63 is not a plaintiff's.
No, this is the
I am talking
Chief
about where
page.
is the cross-examination regarding this.
connected with the defendant. After that date, I was not present. So my suggestion was that this is the document which was created by at the help of
No,
Narayan.
no. You have not, your cross-examination, it is not a suggestion. It should be in a cross-examination that should be there.
But it was put in the cross examination in that affair.
No,
Yes,
this is in form of suggestion.
But it was made by lord. It was
That,
noted.
that I never gave a reply.
Page 55, my lord, can turn to page 50. Cross examination started, and it is in the cross examination.
Nothing you have said about it, about exhibit 5.
Is it right that this is the manufactured document?
Where you have said,
This is the only in that aspect, my lord, it was mentioned. Not a fact that the reply to our notice filed by us is a document manufactured by us with the help of Narayan Chandra Ghosh. This is the only thing which I can come across. But my lord, if your lordship can consider, this is the thing which you put the question to the.
and what you have said in your evidence
Yes, my lord.
about exhibit 5? সব বলছি তো, পুরো admit করে বসে আছে।
কোথায় গেল? ওই রত্ন এই যে। Page 63, my lord, at the top. I received a letter from plaintiff. I handed over to Narayan. I received another letter from the plaintiff. My daughter read over and explained the letter to me, and I came to know from that the plaintiff.
That is a different reply to a letter.
Yes, that reply was not given.
I received a letter from the plaintiff and I handed over to the Narayan. Now, question is, this letter, the reply contains your signature.
No, it is.
It contains your
Subject to correction,
signature.
my lord. Subject to correction, my
At
lord.
the word. Please come to page 19 of the part 2. Contains your signature. And look at the contents of this letter. Damaging. It damages your case. You have admitted that I entered into an agreement for sale.
If your lordship can consider, this was explained. It is Narayan who asked me to put some.
But where is your evidence? I just wanted, sir, that it is the reply I never intended to give. It is only the Narayan who has received. On this letter, it was marked exhibit without objection, sir. Mr. Counsel, show us the portion.
Well, this letter has not been,
And this is a very damaging letter, sir. Have you seen that? So,
admission, if my lord kindly consider, because my case was that I put the signature, my case is that it has been manufactured with the help of Narayan, this reply. Because my lord subsequent reply, your lordship may kindly consider the next page. Page 27, my lord kindly. পড়েছি এটা। না, এটা না। পরে যে চিঠিটা দিল তার উত্তরটা, এই যে। If your lordship may kindly consider page 5, volume 2. This is a subsequent letter which I came to know. এই যে এটা, এর উত্তরটা কোথায় গেল? এই যে, এই যে, ওই উত্তরটা কোথায় গেল? যেটা একটা দিলাম, একটা যেটা পরে উত্তর দিয়েছিলাম উকিলের থ্রু দিয়ে। If your lordship may kindly consider, if your lordship kindly consider the notice itself and the letter under reply, my lord will find the contradiction itself. May I read out the notice, my lord? Whereas previously on 14th day of November, page 9, my lord, I am reading out the notice.
no, I'm talking about a reply.
Because my case is that there has been manufactured.
But so far as exhibit 5, you have not said anything, sir. And it does not appear if you have put a signature in a uniform manner at the top of all the papers.
Top and the bottom. That's why, my lord, some signature.
No, sir, it is, these letters are at the bottom.
Yes. কোথায় সেই কেস মেজার কোথায় আছে সেটা? ম্যানুফ্যাকচার করলো সেটা। If your lordship may kindly consider page that the judgment on the page 106, my lord.
Forget about a judgment. When we are
exit
hearing
by
a
during
first
evidence
appeal,
given at tried to said that she put her signature in blank.
that is an oral argument.
In the evidence, my lord, during evidence
But
defendant,
show us that there is an evidence.
my lord, I have to, because in the evidence,
Because if there is nothing, this finding may be perverse.
evidence the plaintiff sent two notices defendant demanding the completion of the cell. Exit 5 was defendant's reply to one such notice.
This is
Exit
what
5
is
was defendant's reply to one such notice.
correct.
The defendant admitted her signature in exhibit 5.
Yes.
During evidence,
So-
defendant tried to say that she put her signature in blank papers which he had converted into reply. But
That's
no
the-
such
that's
thing is
the-
made out in the written statement.
No, that is wrong because there is no evidence.
So we are able to দেখি। My lord, may I go through once, my lord, to show the records itself, because I
Look at the records, I do not find.
now next day, my lord, I will complete, my lord. This is the only thing I have to argue. After that, nothing is there. So one thing, my lord, whether my illiteracy was a literacy has been proved by the court. I categorically submitted before the court that I am an illiterate, I am able to put my signature. Nowhere in any of the documents it was mentioned that it was read over and explained to me. On the contrary, the plaintiff in his case categorically said that the agreement was read over and explained by Ratna. Apart from that, the plaintiff herself gone through the documents itself. And not putting that question in cross-examination amounts to, my lord, subject to question, my lord, whether it can be treated as an admission on the part of the plaintiff that I am an illiterate lady. They are entitled to get protection as an available to illiterate lady. Though not for the ownership.
Yes,
7 except my lord will go through the entire proceedings. 7 except the signature of Binapani. Apart from that, no other things was brought to the notice of Binapani to say that you can, this is a document after which you read over, and after that you put a signature. Only the signatures are marks exhibit which has been tendered to Binapani.
when,
As a lordship, my lord. As an when your lordship. Monday probably that matter will continue subject to question, my lord.
next Wednesday? How much time will you take? I do not think more than half an hour.
No, but not more than that.
In the line of judgments. Right from AIR 1924 Calcutta? No,
I rely upon the judgment Ashim Kumar Jana versus Vishwajit Das. Probably that will covers everything.
huh?
It is
The भूल होता तो.
the same thing, whether read about and explained. That was considered all other judgment by your lordship. Mr. Banerjee was there. Everything is how a document can be considered as a manufactured not and read over and explained. Any illiterate person can, to what extent is entitled to get protection. পরে এগুলো পরে দিয়ে দেবো।
Yes. 1930 Calcutta. I was talking about
Everything,
24.
everything has been referred. And the portion, my lord is of the opinion, the portion read about and explained, it is in typewritten, not in handwriting. My lord says, sitting division makes, my lord, if there is any indication in the document that it was read about and explained, that is enough. But here in this document, my lord, your lordship will find, if I can prove that I am an illiterate, then there is no portion that is indicating that it was read over and explained.
Wednesday.
Next date on coming Monday. Coming Monday.
Why?
Execution on
Monday, my lord, fixed on Monday.
the lower court below.
Ask for an adjournment there.
Definitely, Your Honor.
Don't oppose it.
No, series of adjournment has been allowed by the landed court below. Series of adjournment already allowed.
But now we are in the midst of it.
There is a
Ask for an adjournment. Say that the appellate court has said so.
possible fixed on Monday. Master.
Wednesday.
Wednesday,
At 2 p.m.
2 p.m. Grateful to your lordship.
এই বাবা, judgment গুলো দে।